All right, great. My name is Amy Hennon. I am currently vaguely in the way of the screen here. I want to thank you all for coming to the Maryland Volunteer Lawyers Service. If you didn't get a chance to sign in, we'll send the sign-in sheet around. There's breakfast in the kitchen. If you're looking for the restrooms, they are down that hallway and then to the right, and you need a key, and the key is at the front desk there. If you are going to leave the room, please do me a favor and try to move around this way, because walking in front of the camera, we have a bunch of people that are watching from where they are, so that would be helpful. Hopefully everyone received an email from me, including the people on the phone. You should have gotten an email from me with all of the handouts for today. You would have received it last night. If you didn't receive that email, there's a solid possibility that either I sent too many files and so your firewall rejected me, or maybe I had something incorrect. But either way, shoot me an email if you did not receive the handouts. There are handouts that are available within the presentation. If you look within the GoToWebinar presentation, if you look down at the very bottom of the screen, there should be a thing that says handouts 5 out of 5. There are five of the handouts that are in there. There are a couple of additional ones. But if you didn't receive all the handouts, send me an email, which is ahennon, AHENNEN, at mblslaw.org, and I will make sure that you get those. And then the last thing I want to do before we get started is I want to introduce Emmanuel Turnbull. He's an associate with the Holland Law Firm in Annapolis, and he practices consumer protection law. He got his law degree from Oxford, and he holds an LLM from the University of Maryland. So he, in addition to all of that, he teaches, in addition to all of his work, he teaches legal ethics at the University of Baltimore, and he does a lot of really wonderful volunteer work for us, including with analyzing the database work that we've been doing. So Manny is great, and we're delighted to have him here today. He's incredibly knowledgeable. So with that, I'm going to turn things over to Manny.
All right. I'll get this presentation going. Okay, so I'm here talking about defending debt buyer cases. If I keep glancing between the live audience and the camera, it's because there'll be people watching through the camera. So sorry if you feel ignored, and you guys too. Okay, so this is the outline of what I'm going to talk about. I'm going to start with who debt buyers are, what they are, and how they operate. Then we're going to look at the law governing these debt buyer cases from the defense side. What documents do they have to get admitted to evidence in order to prevail at trial? Then I've got an example case that I've written all over. Then we're going to look at some affirmative defenses as opposed to simply putting the debt buyers to proof, because there are some typical affirmative defenses that you might come across. Then we're going to look at how the debt buyers would prove their case, how they get things into evidence, all those issues. And then I've got a few more examples for you to look at, and I'm going to conclude with some brief remarks about the difference between defending a debt buyer case and defending an original creditor case involving a credit card, because usually the debt buyer case is a credit card. Original creditor cases are harder for various reasons. Okay, so who are the debt buyers? Well, these are 4 of the largest debt buyers in Maryland. And thanks to MBI's database, I know approximately how prolific they are. Midland Funding is the single largest filer in Maryland District Courts. There is no other entity that files as many District Court cases as Midland Funding. The others are somewhat smaller, but after years of inactivity, some other big players are coming back into the market. LVNV Funding, they were sued a few years ago. They stopped filing suits. They started filing again fairly prolifically. they might end up second Midland funding. Okay, but apart from having these kind of weird names, what are debt buyers? Well, fundamentally what they are is speculators. What they do is they approach original creditors, your Capital Ones, your Chases, your Bank of Americas, and they say, would you like to sell us all your bad debt for some fraction of the face value? And they buy debt from those big banks, and then they try and collect the full value of the debt, usually by suing people. So Midland Funding will typically pay less than 10 cents on the dollar for the debt that it buys, the price depending on how bad the debt is. So really old debt, debt which is suspect for some reason, debt which someone else has tried to collect already, is cheaper. So that's what they do. All of them have basically the same model, they just approach it in slightly different ways. Now usually before they sue, they'll do the usual collection stuff, right? They'll send letters, they will write to your clients, they'll try and persuade your clients to agree to pay money to settle the debt. And then ultimately, if that doesn't get them anywhere, they will sue. They don't do anything else. You will never get a case where any of these people actually lent money to someone. That's not what they do. Sometimes their pleadings might make it seem that way, but they don't. It's worth noting at this point, by the way, that Midland Funding is a subsidiary of Encore Capital. It's a multinational entity. It is probably the largest debt buyer in the entire world. It's worth billions of dollars. So that's who you're up against in the debt buyer case. It's some small piece of the Encore Capital machine. So that's the flow, that's the model. You buy the debt cheap, you make some attempts to collect. If that doesn't work, you file a lawsuit. And in 90% of cases, you get a default judgment. By and large, consumers do not defend themselves in district court collection suits, as you probably know. And even fewer have an attorney to defend them. And for that reason, the rules in Maryland, particularly related to debt buyers, have been strengthened in recent years. The rules for default judgment were changed completely. Effective, I think, January 1st, 2012, 2013. That's in Rule 3306. We're not really concerned with Rule 3306 today because that applies only if the consumer doesn't defend themselves. If someone approaches you and you decide that you're going to help them out, Rule 3306 doesn't really come into play because you'll file a notice of intention to defend and the case will go to trial. 3306 only applies if the case is coming up for affidavit or default. What does apply for any case filed after October the 1st last year, October the 1st, 2016, is a new part of Courts and Judicial Proceedings, 51203. So the 51,200 part was added specifically to deal with some problems in consumer debt collection. One of the things that it rather helpfully did was it prevented the statute of limitations from being renewed. If the statute of limitations expires on consumer debt, that's it. Nothing can revive it now. But mostly what it did was regulate what debt buyers had to provide at trial. So the broad requirements are these. First, no matter the amount of the claim, you get the rules of evidence. Before, claims under $5,000 would of course be small claims, there'd be no rules of evidence, and typically the debt buyer would show up, just the attorney, no witness, with a stack of papers, and just offer the entire stack into evidence with no foundation, no attempt to justify them as business records and so forth, and say, well, it's a small claim, the rules of evidence don't apply. And most judges would accept that. So the first innovation of 51203 is that the rules of evidence do apply in any debt buyer case, regardless of amount. Okay, the next part is substantive. 51203B prohibits the entry of a judgment without specified proof. And the proof is very similar to what's required under Rule 3306. In places it's verbatim. And I've tried to provide a sort of helpful cheat sheet, which should be in the material, which kind of sets this out more usefully on the screen. But broadly, these are the things they have to prove. They have to prove that the debt existed in some sense. There are a few ways they can do that. Sometimes they will have to prove the terms. They will always have to prove that they own the debt, because remember, the name on the statement, the name on the contract, is not going to be the name of the plaintiff. So you need some proof that the right person is suing. They need to prove that the debt they bought is your client. They need to prove the identity of both the account and the debtor. They need to provide a statement which shows how much money they bought, what was the amount of the debt that they bought. And they have to provide a statement about their licenses. That's because for many years, those really huge debt buyers, despite being large and rich and sophisticated, could not be bothered to obtain Maryland collection agency licenses, and they were illegally filing thousands of lawsuits. So now they have to put their licenses on the court papers. They have to give license numbers. Very unlikely you'll find a debt buyer who isn't licensed these days, because they've all been sued or disciplined by the state. But you never know your luck. What you may find is debt buyers collecting from a premises that they don't have a license for. All right, on to the details. There are a handful of special cases. You will almost certainly not encounter these, but there are certain entities which don't count as debt buyers for purposes of 51200. This is really sort of specialist things like property managers and that sort of thing. It's worth bearing that in mind if you get something that looks a bit odd, that's not LVNV funding or something or other recoveries. But generally, if the debt buyer is suing, they will use the right forms and they'll let you know that they're a debt buyer. Okay. We're now going to turn to example A, which I've written all over and I've given it page numbers and things. This is an example of a case that I defended. In fact, it was my first trial in the district court. And I'll let you know the basis I defended on it later. I don't want to spoil the surprise.
Do you want to pull up or not?
Yeah. Do that. Okay. So this is example A, and I'm just going to go through it and show you the various parts first, and then we'll come back and look at the details. So this is a fairly standard complaint form, but you'll notice up here it tells you that this is an assigned consumer debt case. It's a slightly different form. This here, all of that, that's standard. Setting out their claim there. You'll see that the signature block is the same in every case. You're unlikely actually to encounter these people in court. You might, but it's unlikely. What you'll get is what they call adherence counsel, which is going to be someone who really work for Midland Funding, the plaintiff here. It'll just be someone they've hired to turn up that day in court. Okay, this is the Rule 3306 checklist, and this is where they tell you how they think they've met the various requirements. So first, yes, proof of existence of the account. There are 3 ways that they can prove the existence of the account. They can give you a signed contract. They can give you a printout from the original creditor, which shows some kind of transaction. The theory being, if you use the card, use the account, you agree to its terms. Or they can give you a bill, usually a credit card bill, that shows some actual activity. That means a payment or a purchase or something else which is the debtor affirmatively using the card. And they tell us here that they're going to do that. They're going to give us a bill. Okay, proof of the terms and conditions. So this requirement only applies in certain circumstances. Debt buyers have to prove the terms and conditions of the account when they matter. And they're determined to matter when the debt buyer wants to collect attorney's fees or interest after the charge-off date. So the original creditor will have calculated interest before the charge-off date, and that apparently is fine without knowing what the terms are. But after the charge-off date, if the debt buyer is saying, we want 6% on the debt we bought, they have to provide the terms and conditions. Likewise, if they want attorney's fees, they need to provide the terms and conditions to prove that they're entitled. Generally, they won't do that. Now, the other requirement to use this nice little loophole is the person they bought the debt from has to be like a major institution. It has to be something that's regulated by this federal body. Here, the Federal Financial Institution Examinations Council. Really, that means almost any large credit grantor. The only exceptions really are going to be sort of Maryland state entities. Okay, they have to prove ownership. Well, that's not really how they're supposed to write this form. It's be attached. But they do it sometimes. What they're supposed to say is, this is the original creditor, they sold it on this date. This is the next person, they sold it on this date. And at the end should be their name. Right, they've got to identify the account. Original creditor, they've got to give the name of the defendant. I blacked that out to my client. Social security number, original account number, type. Okay, they're being nice and vague there. A line of credit. Usually that will only let you distinguish between whether it's open-ended or closed-ended. So is it a one-time loan that's paid back by installments, or is it a credit card or something like that? Then they're supposed to give you some information about the charge-off. Debts of accounts are not charged off is something you probably won't have to worry about. And then there's their licensing information. And as you see, they have plenty of licenses, just in case. All right, of all this stuff, only these numbers up here and your client's name are actually unique to the individual case. Everything else is generic. The chain of title is for a whole batch of things. And as you'll see, they have an entirely generic statement of case, most of which is entirely irrelevant. All of this down here is self-serving, generic non-allegations that talk about how nice they are to people. I will leave you to read my commentary another time. Okay, then you have a generic affidavit. And really all the affidavit is for is to try to get in the document they need for affidavit judgment. Right, the document is supposed to be attesting, we really bought this stuff, and the information is in our computer and it's our business records now. It's worth remembering, of course, that this affidavit is not itself a business record that could be admitted at trial. What this is written testimony. So they shouldn't get this in at trial. If they want someone to say all this, they need to bring a witness. Okay. The only really useful thing in here is this. This is the chain of title. And you see this debt passing rapidly through a bunch of entities before it gets to Midland. Worth paying attention to the dates, just in case they don't match up with the actual documents or they're in the wrong order. We used to see that sometimes. Debt buyers purchasing debts before they were sold and such like. They're a bit more careful these days. Okay, here we get to the important stuff. These statements, this statement, is specific to your client. It's not going to look exactly like the statement your client would have gotten it to print out. And you see, yeah, there's a lot of payment, which is important for limitation, but also because they're showing that there was activity. All right, this is what a bill of sale looks like. You'll see here this is from one of the intermediate purchasers. The bill of sale is also generic. The bill of sale isn't for your client, it's for a bunch of people, probably thousands. And it will point to a document. In this case, it's this Excel file. And what it's saying is, we're selling you the accounts of everyone who's named in that file. So all of this is generic, so these important people only have to sign once. Yeah, I'll come back to that in a minute. Okay, here's some more affidavits to try and bolster their evidence that they really do own it. Even more affidavits. Again, not admissible at trial unless they bring a witness. There's another affidavit. See, another different file is being referenced there because it's a different person doing the sale. More affidavits. Okay, this is the other document that will be specific to your client. And this is meant to be the data from the sale file. It's meant to be the data from that Excel spreadsheet that was mentioned in the bill of sale. It doesn't really look like a printout from an Excel spreadsheet to me. And I know that actually there is more information than this in the spreadsheet. They'll redact some stuff, date of birth and part of the social and account number. This is important because you can check these numbers against the numbers that appear elsewhere, because sometimes they will not match up correctly. And here at the bottom, just to try and make sure that it's clear that they're saying this comes from the sale file, they include this statement. Okay, I'm just going to skip back. So here's the summary. Most of that is entirely generic, and it's written for the purposes of filing the law. Some of it is slightly less generic, but is still about the sale of an entire batch of debt. And then only a few things are specific to your client. And I've given the page numbers in brackets there, so you can look at those things at your leisure. So statement or statements and data line are really the only things that are evidence specifically related to your client. Okay, so as we look through the document, what are we going to look for? How are you going to find things on which you can base a defense? Well, the first thing to look for is, do these papers comply with, that should be 5.1203, not 4.1203. Do they comply with 5.1203B? Because the documents they file are probably going to be the documents they'll rely on at trial. So let's have a look. Do these comply with the statute? Okay, well, let's see. They're not claiming interest. Good. No attorney's fees. In fact, they helpfully state that they're waiving everything, just to be clear about it. And this is from debt from Credit One. And I happen to know that they are covered by the Federal Financial Institution Examinations Council. So there is no problem there. They don't have to show the original terms of the contract because they fall into that exception. And that will usually be the case. These days, they don't usually ask for attorney's fees or interest after charge-off. Okay, but they still need to prove a bunch of other stuff. Okay, they say that they're going to prove that using the credit card statement. Well, let's have a look at the credit card statement and see if that meets the standard. Okay, here's the credit card statement. This is meant to be what fulfills 1B requirement. So that is supposed to be a bill showing purchase, payment, or other actual use. Well, okay, we've got a payment there, so that looks right. There's some funny things on here, though. Item was transferred from lost/stolen account. That sounds a little bit suspicious. And also, look at this. The balance is something like twice the credit limit. Isn't that a bit suspicious? How on earth do you get a balance that high on a credit limit that low? Well, we'll come back to that. Let's look for our next requirement. Okay. Proof of ownership. This is an interesting one. Okay, so that's their chain of title. Credit One, MHC, Sherman, Midland. Just by the way, all three of these entities are really the same thing. They're all part of the Sherman Group. They're all owned by the same corporate parent. And they're just shuffling the debts around between them. Credit One is the originator. They sort of do low-limit cards for people with bad credit. And then Sherman Originator is kind of a debt buyer type entity. And then the debt either goes to an outside entity like Midland. Midland isn't part of that group. Or it goes to LVNV, which is part of that group. Okay, statement. Let's have a look at this bill of sale. Okay, MHC. Well, that's interesting for a start. Why are they starting with MHC, not Credit One? Okay. Bill of sale, sales for good and valuable consideration, etc., etc., etc. And then notice this down here. Credit One Bank hereby acknowledges the above referenced sale. Why is Credit One Bank acknowledging the sale on this bill of sale? Where's the bill of sale for Credit One Bank? And the answer is there isn't one. Because, as these affidavits attempt to explain, Credit One kind of sells its debts to MHC on the fly. It sells debts as soon as they're originated to MHC. But that doesn't get them over the fundamental problem, which is that the statute requires a bill of sale or other document transferring ownership to be admitted at trial before a judgment can be entered. So this is a potential problem in any Credit One case or any other cases like this, where there is no actual bill of sale between the originator and a subsequent purchaser. Obviously, they try to fill it in with this, but this isn't the instrument that transfers ownership. This is an after-the-fact statement, years after the fact, probably. All right, so that's a potential problem. What else have we got? Okay, does all of this stuff line up? Well, that is something, this amounts of post-charge-off payments, that's something you have to talk to the client about. Because sometimes people will have made payments not knowing that their account has been closed and sold on. Sometimes they'll be paying through like a credit repair service or a debt consolidation service. and sometimes the payments will fall through the cracks. The original creditor will fail to pass them on to Midland, or they won't be properly credited. Something can go wrong, and so it's always worth checking that that's right. Okay, date of last payment, that's important for limitations, of course, and the date of charge-off, important for similar reasons. And the charge-off balance, okay, so they should be suing for that minus that. Just check, and they are in fact suing for $100 less than the amount they bought. All right. The next requirement relates to the data line. They don't just need to produce a bill of sale showing that they bought something, because that doesn't prove that they bought your client's debt. They need to provide some specific reference. What the statute actually says we'll look at later, but there has to be a specific reference to your client, and that is supposed to be provided in these documents through this data line. Now, I've got some problems with that because, firstly, I don't think that this is actually a printout from Excel, because this is not what Excel looks like if you print it out. It's been adjusted to make it prettier, at least, and there are lots of additional fields that I know must exist that aren't here. And then this, are they saying that this is part of the Excel file? Well, no, that can't be part of the Excel file. That's not how those things display. What that is an after-the-fact statement added by Midland Credit Management, which is a subsidiary of Midland Funding, that's added to persuade the court that this is kind of part of the bill of sale, it's part of the sale file. But how are they going to prove that at trial? Well, I think they need to provide someone who can testify where this came from. Also note, of course, that there should, I suppose, be one of these for each bill of sale, because the sale file is different in each case. And they need to prove not just that they bought this from the last seller, Sherman in this case, they need to prove that Sherman bought it from MHC before then, and that MHC bought it from Credit One. This specific debt, not just a pool. Because, of course, if Sherman sold them something that Sherman didn't own, Midland doesn't have good title to it. All right, apart from that, this fulfills the other specific requirements. So it has to contain the social security number, the last few digits of the account number, name of the original creditor, and so forth. All of that is there, or at least it would be if I hadn't redacted it. Okay, and we've seen that they have a bunch of licenses, so that's fine. And they have provided the statement about the amount that's being sold. Okay, so there are some problems with it, but broadly it appears to comply with the requirements of the statute. Okay, inconsistencies or errors, well, we didn't really find any, not at least numbers. It's worth keeping an eye out, though, because sometimes you will see mistakes in these things. Anything suspicious? Well, yes. The transferred from lost or stolen account thing, that's a bit suspicious, and the amount compared to the credit limit, that was suspicious. Okay, talked about that. Yes, we talked about that. Okay, so things to look for on that account statement. One particular thing I have seen that you will sometimes get is where they confuse a payment and a purchase and a fee. So sometimes the last transaction is not actually your client buying something or giving them money. It's them charging your client a fee. And of course, that's not good enough, because that doesn't show that your client is using the account, and it doesn't extend limitations. So keep an eye out for that. The other thing to look for, of course, is incorrect amounts being asked for. And you will see in the records of the district court a bunch of cases where they don't get affidavit judgment because the judge, when he reviews the papers, notices that the amount on the bill of sale, on the complaint, is different from the amount on the last statement. Okay, the bill of sale, we talked about that. The data sheet, we talked about that. Okay, affirmative defenses. I've listed 3 here. There are probably a lot more things that can potentially go wrong. But these 3 are ones particularly to account for. Okay, firstly, identity theft. You won't necessarily see identity theft clearly from the papers. It's something that you have to talk to the client about. If they are a victim of identity theft, probably they will tell you about it. They will say, I never had a credit card in that bank, or they'll say, I had a credit card, but I paid it off. I had a credit card, but I never spent this much money on it. Another thing to look out for is the balance being much higher than the credit limit. I'll explain why in a bit. Also, of course, if someone has been a victim of identity theft in the past, and they know about it, they tell you that, that's a cue potentially for identity theft in the future, because once your social security number and your name and address and so on are out there, you tend to become a serial victim of identity theft. Okay, and that brings me to the defense I actually used in the example case, which was identity theft. And I will show you the clinching piece of evidence, which is this. Here we have a client who I think could reasonably be described as a little old lady, who like buys gas and goes to Whole Greens on this card, buying gold and silver bullion, subscriptions to eVow, making large purchases at big box stores. That's usually a good sign someone's doing something dodgy. And then making these ginormous payments. And what they're actually doing there is this payment is fraudulent. That payment's going to bounce. And the reason the thief is doing that is to enable them to get more money out of the account. Because they make those fraudulent payments, that brings down the balance, at least until they bounce, and that enables them to squeeze in more purchases and not go over the credit limit. And then all of those fraudulent payments will bounce, and the balance will end up being way higher than the credit limit, because that's what the thief intends. They're trying to get the most they can out of this account. You also see that they've increased the credit limit and they're making these rush payment fees. So with evidence from the client and with such obvious fraudulent transactions as this, I was able to convince the district court that, oh, my client didn't run up that ginormous bill. But nevertheless, Midland did push this case to trial. Despite knowing this, they had known about this for a long time before they even filed suit. They did it anyway, and their counsel on the day had never seen this document before. In fact, he had not even read my client's notice of intention to defend before coming to court. So that's what you're up against. Okay. Okay. Another thing you might encounter is mistaken identity. Sometimes hard to distinguish from theft. Typically, you'll get someone with a common name. Sometimes it'll be father and son. That the senior or the junior gets cut off, and the one is accused of owing the debts of another. It can just be completely unrelated people who have common names. Usually, of course, they will not have the same address. Often, if you check their credit files, you get them to go to annualcreditreport.com and pull their credit reports, and you may discover that they have a mixed file, which is where the credit reporting agencies confuse two people. And that can cause collectors like Midland to go after the wrong person, because Midland just relies on what the CRAs tell. Okay, another thing you can get is authorized users being sued. And this potentially will go for original creditors too. Authorized users are people who can use your credit card. Usually they have a second card with their name on it, but they're not obligated to pay on the card, usually. And sometimes creditors and debt buyers don't make the distinction. So it's worth keeping an eye out for that. Again, probably your client will know, but it's worth keeping an eye on things like the data sheet, data line. And if it lists them as co-debtor or something, be a bit suspicious. All right, statute of limitations is another good one. The default is 3 years. For certain contracts, sale of goods contracts, it's 4 under the UCC. You're unlikely to have a debt buyer suing on a contract under seal. So the starting point for limitation in these cases is default. That is, when did the person first fail to make a payment? Because that's the date when they could first have been sued. Of course, you can extend SOL in various ways. You can extend it by making an explicit promise to pay. You can extend it by making payments on the account. There are some things that won't renew part payment, won't renew the statute of limitations. Payments by spouses don't necessarily. They would have to say that the spouse acted with the knowledge and consent of your client. And if they have a dispute about the amount of the debt, and they say they're only paying the undisputed amount, that doesn't renew SOL on the rest of the debt. Usually these days, again, debt buyers are careful about the statute of limitations, but because of other mistakes they make, like confusing a fee with a payment, sometimes they will get the statute wrong. And there is a new special rule, as I mentioned before. 5.1202 says that once the statute of limitations has passed, the debt can't be revised. So that doesn't mean that payments don't extend the statute. It means once you've had 3 years with no payments, no promises, 3 years after the cause of action accrued, once that time has passed, that debt can't be sued on at all by anyone. And that prohibition doesn't just apply to debt buyers, it's any consumer debt. And it's worth bearing in mind, particularly in debt buyer cases, because if they're suing beyond the statute of limitations, they're breaking the law. And your client has a potential suit against the debt buyer for that. Okay, I've brought along some more examples. These are really ones that you can look at your leisure. These ones don't involve identity theft. So let's have a look at this. Look at this first one, example B. Okay, this is another Midland funding case, but it's a bit older. We'll see how things used to be done. As you can see, this is quite a large account. Their explanation is slightly different, but broadly it's all the same. You know, OC attached, managed to get things right there. But there is another problem with this account. I'll show you in a moment. Okay, this is something that you should really see in all cases against individuals. This is a printout showing that your client was not protected by SCRA. SCRA is the Service Member Civil Relief Act, and there are special rules that apply if you try and sue someone who's on active duty. Okay, here we see a completely different kind of bill of sale. This is straight from the original creditor to Midland. See, they've redacted a bunch of stuff. Who knows what those say? Probably they're telling you the amount they spent, and they don't want you to know that. Okay, no idea what purpose they think this document serves. It doesn't really tell you anything helpful. Okay, affidavit of sale, yeah, we don't care about that because it's not evidence. Okay, they provided a statement. But you see what I'm talking about here. There is nothing to show that there was activity on this account. There's only a late fee. That doesn't prove that the person being sued ever used this account. And this is the only statement in there. And then there's just the sale file. Notice how similar this looks to the other one, which is kind of further proof that this isn't straight from the Excel spreadsheet, that they formatted it specially. And again, they're nice little self-service statements. Okay, this is actually from a case that involved sewer service. It was filed long ago, in 2012 or 2013. But the person was never served, and the first she heard about this was wages being gone. Right. So that's example B. Note the missing element. If this case were filed today, they would not have the documents they need to fulfill the requirements of 51203B, because the statement does not show a transaction. And so if you look at the cheat sheet, it's the box at the top, right in the middle there, bill of sale showing purchase, payment for actual use. Charging fees is not actual use. Oh yeah, I should probably just pull up. Okay, here it is in pretty colors. I've kind of colored these things to try and indicate what you're most likely to see. What you're most likely to see is in green. Things you're very unlikely to see are in red. And so the requirement that's missing from example B is this. It's B31. It doesn't have any of these three things because there is no purchase, payment, or actual use on that statement. Of course, that doesn't mean that they might not come up with more documents at trial, but if this is all they have, then under the statute, they shouldn't win. All right. Okay, example C. Okay. If anyone practices in Peabody County and to a lesser extent in Montgomery County, you'll see these things. Kind of different writ of summons. In those places, there are special dockets with these resolution conferences. The function basically is to force defendants to show up and talk to the plaintiff's attorney. So they do provide, so they say for a trial on the same day if you want one. But of course, if people don't turn up, that's treated as a default. Okay, here we see a different creditor this time. This is LVNV. Courtesy of Resurgence, that's just another subsidiary. Different set of people who you may or may not see at trial. And you see broadly similar elements being claimed. Right, they provide the list. And you notice something here? Credit 1, Sherman Originator to Sherman Originator to LVN. This is fundamentally the same chain of title as before. As you'll see in a minute, it has the same problems. LVNV, at last, is licensed. Yes, they've got the certificate. They've got the statement. Again, what's missing? There's a late fee, there's an annual fee, there's no transaction. Well, let's see, do they have another statement? Okay. Here they have a statement that shows some actual purchases. Clearly your client has a sick pet. But that's sufficient. That's what really the statute is looking for, some transactions that show that the account is being used. All right, the bill of sale, does this look familiar at all? MHC, FNDM, Credit 1, and Credit 1 is acknowledging the above sale. Again, I don't think that this document is actually transferring, it's not the document that transferred title from Credit 1 to these two entities. And why there are two of them, I don't know. What it seems to be saying is that Credit 1 sold one slice of the debt to these guys, the other slice of the debt to those guys, and these two are now putting the debt back together in order to sell it to Sherman Originator. All right, these are fairly standard transfers and assignments. They're transferring the debt on Sherman. And then I have no idea what they think this is. And then there's their custodian of record certification. Okay, what else is missing from this? Well, unless this is supposed to be it, these guys don't have the data line. Right? They have some bills of sale saying we bought stuff. B33, they have to provide a transferring instrument with specific reference to the defendant. Well, there's no specific reference in the transferring instrument. There isn't even the usual data line they provide. There's only the statement. And the statements don't prove that those documents transferred title to this particular debt. Also, where's this stuff? Account number, social security number, I don't think we saw that anywhere. Certainly not on this document. This just tells you some numbers. Not in there. Not on the statements, because you don't put social security numbers on statements. Well, okay, it alleges what the last four were there, but how are they going to prove it? Okay, so those are the examples. As you can see, there are potentially problematic things in all of them. All right, so let's suppose that you haven't found the solid gold case with the gold and silver bullion, and your client's recollection basically is that they had the card at some point. Yeah, they know they didn't pay on it. They don't really know how much is owed or when they last used the card or any of that stuff. Then your defense is basically going to be put to proof. Right, you want the debt buyer to prove that they really are the right people, that's the right amount, and they need to have all of the evidence required by 512.03. And there are two ways they can go about this now. They can bring a witness, in which case it goes the usual way. Right, they lay foundation for these documents through their witness, and voir dire the witness as to their knowledge, and they'll try and get them in under the business records exception. In which case, the relevant questions are going to be ones like, do you actually know how this document was created? Who created the data line? Is that what it looked like in the Excel file? Did you look at the Excel file? And so forth. The alternative, and probably what you'll see more often, is that they try to use Rule 5902. Rule 5902 is a method for admitting business records, or at least confirming the authenticity of business records without bringing a witness. They will send your client a Rule 5902 notice 10 days before trial, and your client has 3 days to object to the notice, which realistically nobody does. Usually they will send the 5902 practically as soon as the person files a notice of intention to defend. Oh, I didn't realize you could do that. Okay. So what they will try to do is use this 5902 notice to avoid needing to bring a witness. They'll say the defendant didn't object to the notice. Therefore, the document is presumed authentic without any witness evidence, and so they can just be admitted as business records. One thing I just became aware of to look out for there is that sometimes they will send the 5902 notice, but they won't actually send any document. They'll send a covering letter saying something like, the documents are available for inspection at our offices. Now, the rule says that they have to make the documents available, whether or not saying they're available at our offices in a different county is really sufficient. I don't know. And of course, if your client goes there, they may or may not actually be allowed to see documents. All right, attacks upon proof. Well, if you get the chance, you should object to the 5902 notices. The basis for the objection would be that, well, you know, the documents they're filing are potentially unreliable. You don't know really where they came from. And if you need evidence of unreliability, you need look no further than the consent orders most of the major debt buyers have with the Consumer Financial Protection Bureau. Pretty much all debt buyers who are active in Maryland have at some stage been sued for doing naughty things, often involving falsely stating that they had personal knowledge of certain information. In addition, most of the actual contracts, the contracts for the sale and purchase of debt between them and the original creditors will say something like, we don't guarantee that these debts are actually owed. We don't guarantee that they're within the statute of limitations and that they're not the result of fraud, and you're buying them entirely without any warranty, which kind of casts doubt on whether the documents they provide should be admitted, just on the say-so of MIM or any other debt buyer. Okay, if they try, obviously you can object to their trying to use affidavit as evidence at trial, because that's not the proper function of an affidavit. An affidavit is testimonial. Business records are something else. Affidavits are written for the purposes of suing people. It's clearly the case here. It's why the affidavits exist. And so they're not really business records in the normal sense. And finally, of course, if they bring a witness, you can voir dire the witness and show their actual knowledge. And usually their actual knowledge is limited to, I looked at a computer screen and it said that. All right, if you bring your client to a debt buyer trial, the debt buyer will put your client on the stand. Now, people have different views about this. Some people just don't bring their client if they think that there's going to be a problem with proof, because the client can maybe get some stuff in. And sometimes that could be important, but I think usually the debt buyer is not going to be able to do much with your client. Because realistically, all your client is going to say is that at some point I owed some money, and yeah, that looks like a statement, I guess. They can't testify to the chain of title stuff. They don't know exactly what the amount was, and the debt buyer is not going to be able to admit many of their documents through your client, because your client doesn't know if their business record regularly conducted activity, doesn't know if they fulfill the requirements for that exception. Your client could only testify that maybe they recognize this as a statement they received, so they can get in a statement. But they still need all the other stuff that 51203 requires. No bill of sale, no no line showing that this person's account is part of that sale, and they should not be able to get a judgment. And your client is not going to help them with that. Okay, some distinctions between these cases and original creditor cases. Well, firstly, for original creditor cases, there is no 12503B set of requirements. It's a matter purely of substantive law. And so you have all these various legal theories on which they could try to recover. And you just need to know, well, which ones are they alleging, and what are the elements? What would they need to prove those elements? Some of these things are pretty unusual. I mean, quantum merit is probably something people see more in law school than in regular practice. And account stated is very ancient and odd. And if you're interested in it, you can read my article about it. Shameless plug. Very importantly, most importantly really, is that the rules of evidence don't apply to original creditors and small claims. The Court of Appeals authority on this is Bartlett versus Portfolio Recovery Associates. And basically, the only door that leaves open for excluding evidence in a small claims case is if you can show the evidence is unreliable. Beyond that, there are just absolutely no rules of evidence. And so usually in a small claim, an original creditor like Credit One, like Capital One, they sue quite a lot. An original creditor like Capital One would not need to bring a live witness to a case under $5,000. So these ones tend to be harder. They're also hard for practical reasons. Right? There's no need to prove the chain of title, because the statement will say Capital One or Bank of America or whatever. They haven't sold it to anyone, so there's no bill of sale business. And there's none of the uncertainty of passing debts from one entity to the next. You don't know anything about warranties. It's the original creditor you're dealing with. Also, original creditors will generally have more access to the documents they need to prove the case. So debt buyers have to pay original creditors if they want additional documents. Usually the contract under which they buy the debt will have terms that say, if you ask us within X many months, you can pay us $5 for a statement, $10 for an application. And so debt buyers often won't acquire that stuff, and sometimes they won't be able to get it from the original creditor. So dealing with the original creditor, they probably have a lot of stuff if they can be bothered to find it and use it. The one bright point is that the rule about statute of limitations does apply to original creditors. So Capital One, if they want to sue you on a credit card debt, they have to sue you within 3 years. And even if you promise to pay them 4 years later, even if you make a payment 4 years later, that doesn't mean they right to do. Okay.
Well, so
I apparently run short.
Well, I actually was going to open it up for questions a little bit, and I know I have some questions for you, but I'd like to open it up to the live attendees here. If you guys have questions, if you want to ask your question, I'll try and repeat it so that the folks that are on the webinar can hear what the question was.
I have two.
Yeah.
First, I just hope everybody realizes that the change in the rules to make things, to make the creditors and the debt buyers more accountable to have the proper information was a result of a whole lot of hard work by a whole lot of people. So it really is an example of when you do battle to try to hold people accountable and change the rules, it really can have an effect, and it did here. I just know when I started, the whole idea of attorney's fees and interest, they just automatically ask for attorney's fees and interest, and we're getting them. So we can't underestimate that. My question is, Manny, the 3-year statute of limitations versus the 4 years. Why is it not UCC?
Okay, so this is really like a law school kind of point. If it's just an ordinary credit card, it's going to be 3 years. The UCC 4-year statute applies if the UCC covers the transaction. So if the entire transaction is predominantly for the purpose of selling goods, which is what the UCC covers, then the 4-year statute would apply. So that would only really be relevant if you've got a debt buyer collecting on something involving like a loan for the sale of goods. So a contract that we might find under RISA or something, they would say, well, it's governed by UCC. One of the complications of these cases often is that these debts will have been originated outside Maryland, so you won't necessarily get the kinds of contracts that you're familiar with. Someone bought a boat in California, they might move to Maryland and get sued by a debt buyer. And then the question is, what statute of limitations applies to the debt buyer's suit to recover the boat loan? And the answer is, well, generally it'd be 3 years, but if the loan was for the purpose of buying the boat, then it could be 4 if it's under the UCC. And so you'd have to do some research in the individual case to determine which applies. But for like 95% of cases, it's going to be 3 years because these are credit card cases, almost all of them.
And if I just want to mention that if folks on the phone on the webinar actually have questions, you can type them into the chat box on.
Yeah, we better show that.
So there's you can type your. I think in that chat box it's at the very bottom, or into the questions box. But I think either one of those is fine. Into the chat box, I think. Are there other folks in the room who have questions?
Okay. I had a couple of questions for you. And I know you kind of briefly touched on, if they sue after the statute of limitations, that's a violation of the law. Can you talk a little bit about the affirmative claims that you guys bring and what the most common ones are?
Yeah. Okay. Okay. So when you're dealing with debt buyers, mostly for affirmative claims, you're going to look at the FDCPA. It's quite a long statute. There's a lot of case law about it. The 30-second summary is, if the debt buyer tells your client something that's not true, even if they do it in the pleading, then the debt buyer can be liable for that. And so the typical things will be telling your person that they owe more than they do, or lying to them about their rights to do something. And so that's why suing after the statute of limitations is a violation, and why it gives your client a cause of action. It's because by filing the suit, they are representing to your client that's the proper thing to do. And if they're beyond the statute of limitations, that's clearly improper, because courts and judicial proceedings now says they can't do that. So statute of limitations we don't see so much anymore. It's still illegal to do it. It's just that the debt buyers are much more cautious about the limitations period. The really great ones are ones where the person does not owe the money they're being pursued for. So example A, for example, is now a huge affirmative claim because they chased this poor lady and took her to court, took her all the way to trial, and by the way, basically accused her of lying on the stand over a debt that she genuinely didn't owe. So the issues tend to be kind of individual ones, individual to your client and your case. The things to look for are really anything that is not true. Anything the debt buyer says that is a lie or misrepresents the truth. And you might see it in all sorts of different areas. You might see it in the cover letter for their 5902 notice, for example. If they say in the cover letter, the documents are here, and your client goes there and there are no documents, well, that could be a violation. Okay, some other things you might see is credit reporting issues. So you might get, for example, with identity theft case, right? Because the money isn't owed, you should go and check the person's credit reports, and you will find that Midland is reporting it as owed. And that's something that can be disputed, and eventually that can give rise to a cause of action. There's also a Maryland statute that governs collection behavior and applies to original creditors. It's the Maryland Consumer Debt Collection, the Maryland Consumer Debt Collection Act, MCDCA, but it's much narrower than FDCPA in terms of its substance. So it covers more people, but the range of things they're not allowed to do is much narrower. The kind of core allegation there is threatening or trying to enforce a right when you know that you don't have that right. So, for example, in the case of mistaken identity, your client has told the debt buyer, I'm not that person, I'm someone else, and the debt buyer proceeds to tell them, we're going to sue you anyway, then arguably there is an MCDCA violation there, as well as an FDCPA one. Another common thing with debt collection, not directly related to lawsuits, but related, is TCPA, Telephone Consumer Protection Act, and its Maryland equivalent. TCPA prohibits using automated dialers to call cell phones without permission. So you'll probably find your client has had about 100 calls from the debt buyer before they get sued. And those calls typically will have been auto-dialed. Went to your client's cell phone, and at some stage your client said, stop calling me, then potentially your client has a TCPA claim. But those aren't so great for a variety of reasons these days. One of which is that you will get sent to the Middle District of California when you sue them. Because there's a multi-district litigation out there, and they're pulling all of their TCPA suits into it. It's becoming a kind of standing court for the debt buyers, the TCPA claims. But for some smaller debt buyers, there might be something there. Same applies to original creditors. If the original creditors collection department persists in making automated calls to your client after a revocation of consent, that could be a good case. It's always worth keeping an eye out for the good cases, particularly if you have an affirmative defense. If you have an affirmative defense, there's likely to be some kind of claim that you can bring. And the thing I would add about that really is that there are a handful of people in Maryland, including Jane and me and a few others, who bring these kinds of cases, and we're always happy to talk to people who think they might have one. And I think all of us sort of do co-counseling and stuff. The one thing I would encourage you not to do is sell out claims of which you don't know the value cheaply in order to settle the underlying debt, which is kind of a temptation. And sometimes I've done it if I don't think the claim is worth much. But in an identity theft case, for example, you'd be mad to do a mutual release with a debt buyer that sued someone for money they didn't know. I guess I should probably mention some stuff about settlement. Debt buyers generally will settle for much less than the face value. And sometimes your client will want to do that. If your client acknowledges they probably did owe the money and they didn't pay because they couldn't, which is not an unusual story, then you can probably get them a reasonable deal from most debt buyers' attorneys. Because really any recovery over like 10 or 20%, they're going to make a pretty big profit on. If they're buying these debts for about 10% and you settle for 30% or 50%, then they've tripled or quintupled, quintupled their money. So there's some flexibility for settling. There can be tax consequences for settlements. That's important to your client, though the amounts are not going to be huge generally with debt buyer cases.
Can you expand on that a little bit? Like, what are the tax consequences?
Okay, so I'll preface this with I'm not a CPA or a tax lawyer. and can only repeat really what I've been told about this, which is that debt buyers will often treat a settlement for less than face value as forgiveness of debt. So they will report to the IRS, we forgave $700 of this person's debt. And forgiveness of debt counts as income to the IRS unless the debt is disputed. And what's meant by disputed is a bit complicated and not intuitive. So if you think that, so if the debt buyer sues and your defense is going to be they don't own the debt or they can't prove they own the debt, that would probably not be a dispute for IRS purposes. But if your defense was, I never owed the money, I didn't open that account, that would be a dispute. So the kind of the conclusion from all that is that if you're doing like a written release or something, you should try to get them to include language that either says it's disputed or says that they're not going to report it as forgiveness. So I should probably also mention 3506B dismissals. If you settle with a debt buyer, they will almost certainly want to do a 3506B dismissal. And usually those are a trap. They're usually a trap for unrepresented people. Here's what they do. They say, how much can you pay a month? And the person says, $25. And they say, all right, we'll do a 3506B dismissal that says you'll pay $25 for 24 months, and then the case will be dismissed. But the 506B dismissal will also say, and if they miss payment, we can get a consent judgment for the full amount of the debt. So if you're going to settle with debt buyers, try to settle as a lump sum, because that's harder for your client to get wrong, and it's easier for you to make sure your client can actually afford the payment. And it will result in less of this 3506B nonsense. You want the case over as quickly as possible. You don't want the client on an extended payment plan, because often they are not really going to know what they can genuinely afford. And their reflex will be to offer more than they can afford to pay, and that will get them in trouble. Something else I thought I should mention about settlement. I've forgotten what it was now. Dang it.
Well, I have a question about cancellation of debt.
Yeah.
So what are your thoughts about somebody who potentially receives a 1099-C cancellation of debt income before they actually get sued?
Okay, that's a bit tricky. Having received 1099-C does not necessarily mean that they can't be collected on, but I suspect that most courts would have questions confronted by a 1099-C in a lawsuit on the same debt. It seems to me that really what the debt buyer is doing there is cheating the IRS, because they get a tax benefit, right? They get a kind of write-off for saying, we forgave this debt. But if they're saying, we forgave this debt, oh, wait a minute, we collected it, that's a little bit suspicious. It has to be said that a lot of this stuff, whether you win or lose, depends a lot on the judge you happen to be in front of. Some judges are good, some judges are not so good. Some judges take the attitude that unless you have an affirmative defense, like statute of limitations or identity theft, they don't want to hear you speak. They will criticize you for putting the plaintiff to proof. On the other hand, some judges have got kind of tired of the tricks that debt buyers play, and they will to some extent be on your side. You know, that they'll take the position, for example, that if the debt buyer shows up with no witness and no 5902 notice, then that's it. Because, Mr. Attorney for the plaintiff, how are you going to prove your case with no witness? You can't get any documents in. So So it is very dependent. If you do these cases a lot, you'll get a sense of which judges will go which way, and maybe that will inform your choices about settlement and so forth.
I have another question.
Yeah.
I mean, I don't want to get too far afield, but how does the new Hansen case flow into all of this?
Okay.
And maybe you can explain that in a nutshell.
All right. We are wandering here. Hansen is a Supreme Court case. I should talk to the cameras more, actually. Hansen is a Supreme Court case. It's to do with who counts as a debt collector for the purposes of the FDCPA. Hansen was, many feel, a misconceived appeal that should not have been pursued. It involved an ordinary bank that purchased defaulted debts from another bank. And the position before Hansen was if you purchased consumer debt in default, then you were treated as a debt collector. But the Supreme Court says, no, that's not how it works. You're a debt collector if mostly you collect debt. Just buying debt isn't enough. And so that's created some problems for FDCPA claims. But for the purposes of this stuff, it doesn't affect who 12503 applies to. It doesn't affect the procedures for assigned consumer debt cases, because those don't depend on the FDCPA definition of a debt collector. They depend on Maryland state law, and Maryland state law defines debt buyers as debt collectors for these purposes. We haven't seen any move so far by the major debt buyers to use Hansen to escape FDCPA liability, probably because they know it would be a bridge too far. Also because they collect through subsidiaries. Subsidiaries don't own the debt, so they would be counted as debt collectors anyway. So it will affect some things on the margins about affirmative claims. It's not really going to affect defenses in these cases, I don't think.
I have another question.
Yeah.
So obviously this all depends on when the client approaches you for assistance.
Yeah.
But what are your thoughts about the timing of the entry of the notice of intention to defend, and what are your thoughts about the timing of when you enter your appearance in a case?
Okay. So to an extent it depends on the case. Often you won't have a huge amount of choice because the client will come to you late. Often they will already have filed a notice of intention to defend themselves. If that's happened and there's some substantial defense I want to raise, I will file my entry of appearance as soon as I've been retained, and then file everything I can think of to file. So for example, you can file an amended notice of intention to defend. There's nothing to stop you. It's not really going to make any difference to anything. But it's a way of letting the debt buyer know you're serious, and this is the defense, and expect trouble at trial. And sometimes that will put them off. Will encourage them to settle if that's what you want. On the other hand, some would take the view that that would merely help them prepare for trial, and that the better thing to do is to surprise them at trial and not file your notice of entry of appearance until day of trial. I don't do that. I don't really like that sort of game playing, but sometimes it's unavoidable. So for the example A case, I was retained the weekend before the trial, and the trial was Tuesday, so I couldn't really enter my appearance before trial. I did it the day of. If I'd been in before, the case might not have gone to trial. They might have dismissed it, knowing it would be properly defended. Generally, they just roll the dice when someone files a notice of intention. They will go to the trial and hope the person doesn't show up. If they show up, they'll try to browbeat them into a settlement. They're very unused to seeing actual attorneys at these things. So generally, I'd say that it depends a lot on what your case is going to be. If your case is going to be a straight put to proof, then I just file the entry of appearance whenever you get hired. And if they want to try and settle, they'll call you. Oh, there is one other thing to point out about that, which is this. If you represent indigent clients, people who are on Social Security only, that sort of thing, tell the debt buyers that, because a lot of them will dismiss cases, sometimes even with prejudice, if they know that the person is destitute and has no money that they can get, because it's a waste of time and money for them to pursue that person. Some law firms are better than others. The Peruka firm, David Schley is now with them. He's very good about the people who don't have any money anyway thing. And you know, if you call them or email them and say, my person is on Social Security, they're judgment proof, you're not going to get anything. If you like, I'll provide you with, you know, a Social Security letter or something. Often that will get you places that no amount of argument will. And it's an easy way to resolve cases for people who can really do without the additional pressure.
My last question for you is, and you kind of mentioned that sometimes the defendants say, well, I know I owe some of the money, I just want to pay, I just want to get it over with.
Yeah.
How do you kind of combat that attitude of, you know what, I just want to get this over with, I don't want to deal with the trial and doing all of that? How do you kind of talk to the client about whether they have claims or whether it's worth it to fight?
Okay, so obviously it has to be a case-by-case judgment. If they have a defense, for example, statute of limitations, then I just explain to them that the law says they had 3 years to sue you. They chose not to do that. That was their choice. They abandoned their right to collect this money from you. You don't have to pay them this money. If you want to pay them this money, you really want to pay them, well, you can do that, and we can probably come to some arrangement to do that. But you're not obliged to. And generally, if people know that they're not obliged to pay, they won't. But for cases where, you know, it's a put-to-proof kind of case, it has to be a discussion of the chances of success at trial, I think. Generally, the chances of success are going to be hard to predict because it's going to depend on the bench and the documents that the plaintiff brings to trial. You know, I've seen them turn up with like a stack of statements that thick to try and prove their case. So you can never guarantee what the outcome is going to be. But generally, I'd say, well, you know, there is no downside to filing a notice of intention. There's no downside to taking the case to trial. And if what you really want is to settle this case and pay them some money and have it over with, then I can help you do that. And that's a judgment for the client to make. Right? I'm not going to push anyone into defending a case if they don't really want to. Yeah.
One of the things that we try to explain to the clients too is that if they do get a judgment, you know, this is what that means. You know, on your record for 12 years and 12 years more, 10% interest rate. You know, that there are dangers of a judgment.
Yeah, that is true. There are. Of course, their wages can be gone and so forth. It has to be said, though, that, of course, some debt buyers don't charge post-judgment interest anymore, which is an upside. And so it depends on their reason for wanting to pay. If they want to pay to improve their credit rating, then there are different things that you would explain to them, such as it may not actually make that much difference at this point, because it's going to stay on their history for 7 years.
I think the other thing that I explain to clients when they're concerned about their credit rating is, what do you need to access credit for? You know, is it just that we think of our credit rating as some valuation of how good we are as a person, and that's the only reason that we want to improve our credit rating? Well, maybe that's not necessarily worth what you want to do here, but if you have a house you want to purchase or something like that within the next couple of years, then it's worth exploring the things that can potentially be done to improve a credit score.
Well, sorry to jump in. The other thing is, as part of a settlement, everything's negotiable. As part of the settlement, you could say take it off the credit, delete the trade line or whatever. And especially if you have an affirmative claim, that's often part of the settlement and affirmative claim.
Yeah, that's often the way it will go. I don't think I've ever actually done take it off the credit report settlement, like trying for that term in a defense posture. Because usually it's not something, usually it'll be an argument about how much the person is going to pay. If the person pays them something, they'll use it as settled, which is better than having it open. But it's worth trying for if it's important to your client. I would have thought that the credit reporting agencies wouldn't like furnishers, like deleting trade lines in exchange for money, but apparently they're fine with it.
And then if they don't do that, if they agree to do it, then don't do it, obviously.
Well, okay, if they agree to do it and then don't do it, well, arguably that would be an MCPA violation because they told you something that wasn't true to get you into settlement. I suppose it could be an FTCPA violation. If you dispute it and they don't take it off, it's an FCRA violation. FCRA is Fair Credit Reporting Act. There are all these wonderful potential affirmative claims you can get in these cases. The difficulty is finding them and then developing them into something that's really worth bringing. Some things, especially FCRA against the furnisher. The furnisher is like Midland Funding as opposed to Equifax, TransUnion. Those cases take some setting up and they can be a bit tricky.
And with these affirmative claims, for folks who may not be real familiar with them, can you explain a little bit about what can someone get out of an affirmative claim, and what can you get as their advocate?
Okay, so most affirmative claims, not quite all, but most, have fee shifting. If you sue under FDCPA, MCPA, any of the debt collection statutes, there are ways you can get attorney's fees. TCPA doesn't have attorney's fees, but it has statutory damages per call. $500 for ordinary calls, for willful calls, $1,500. And so potentially those cases can be very valuable if there's a lot of calls. FCRA, you can get punitive damages and statutory damages if the violation is willful. Obviously, that can be hard to prove. But everything, really, you can get actual damages. Actual damages isn't just, like time your client took off work to come to trial. It can include emotional distress, which can be quite significant if there's been a sort of long history of collecting for something that's really not owed. Actual damages can be fulfilled by them having paid you to defend them, because that's kind of obviously a damage that you would sustain from being wrongfully sued. And potentially, if you find a systematic mistake, if you find that one of these debt buyers is consistently doing something wrong, like a mistake in a form letter, then potentially that's a class action that would recover probably relatively small amounts of money for everyone that they did that thing to. And if that thing is like lying about their rights at trial or something, lying to them in a 5902 notice about what they can and can't do, then that's an important thing to challenge, and class actions are a reasonable way to do it. I'm not going to dive down the arbitration rabbit hole though, because we're kind of running up to time.
I'm going to give a little bit of clarification about affirmative claims and defense posture claims in terms of how it works with the Maryland Volunteer Lawyer Service. So we obviously place a lot of cases with attorneys for pro bono representation, and our funding requires that the representation be pro bono. What you absolutely can do is resolve the matter with the defense case and then work out some other sort of arrangement with the client so that you can sue in an affirmative matter and potentially get attorney's fees. We are not opposed to that at all. In fact, we encourage that. It's just that the two cases need to be separate in terms of one is your pro bono representation that you do through us and the case is placed through us.
But under the rule from a few years ago, even if it's pro bono, you can get attorney's fees.
That is absolutely the case. Legal services attorneys and pro bono attorneys can absolutely request attorney's fees. On the other hand, if you want to keep them as one, the other way to make sure that this is 100% a pro bono situation is just donate whatever your attorney's fees are to us. We welcome that. I am not going to say no if that's how you would like to proceed. But I just offer that up so that you think of the pro bono that you're working on as something slightly separate from a potential affirmative claim that you might pursue.
Yeah. Oh, it's worth pointing out just that you don't have to raise your affirmative claims in the collection suit. There are no mandatory counterclaims in Maryland. So you don't have to file a counterclaim saying you violated the FDCPA. You can deal with the claim that's in front of you, the defense, and then you file a separate lawsuit. That's usually the way it's done.
And that actually might get you a larger settlement in terms of the value for the client.
Yeah, it probably would.
Well, what we do is we do a stay, so I don't know if you want to talk about that to get it out of the district court judge's hands.
Okay, so if you have time and if you think there's a good affirmative claim, here's what you can do. You can file your affirmative claim separately. So you file in circuit court or in the federal district court alleging the violation, and then you ask the district court to stay the collection case pending the outcome of your affirmative claim. And if you've got time to do that, that's a reasonable way to proceed. But you need to make sure that you have enough time to prepare the affirmative claim before the district court trial comes on, and enough time that the district court will actually consider your request to stay it before the trial date, which can be a challenge. Because district courts have a nasty habit of saying on any motion within like a month of trial, oh, we'll just decide it on the day.
And just to give you guys a little bit of context as well with the timing of the district court cases, generally if someone files a notice of intent to defend, trial is set within 30 to 45 days of them filing that notice of intent to defend. So it is a pretty small window of time. So they would either have to come to you before they filed that or immediately after, and hopefully the stars align to allow the district court to consider, your request to stay the case before the trial. But I agree with what Manny said. Generally, if there's a motion or something filed within that time period, the 30 to 45 days before trial, the court will just say, we'll just hear it on the day, and they'll just hear everything before they proceed with trial.
Except if I could jump in, one of the things that we've taken advantage of is the fact that the judges in district court are often overburdened and sometimes a little lazy. So we've actually done them with very little time before trial and had them granted because it's one less thing they have to deal with. So it's what you're saying is absolutely accurate, but human nature being what it is, one less case on the docket. I've only had a stay denied one time.
I can see that being tempting to dismiss.
So I think with that, we're going to pause things here. We'll take a 15-minute break, and we'll please feel free to get a snack or what have you, and people on the phone will be back with you shortly. we're going to jump back in, so now we're going to transition to talking about bail bonds. We're very lucky to have Jane Santoni, and also with her is Chelsea Ortega. They both are at the firm Santoni, Vacchi, and Ortega. Surprise, in Towson. Jane has over 30 years of trial experience, and her primary practice areas include car accidents, nursing home negligence, slip and falls, credit reporting errors, so those FCRA claims that we were talking about earlier, debt collection abuse, and landlord-tenant issues. And she has litigated a serious number of bail bonds cases as well. She's the president of the Board of Directors for Civil Justice. She's a member of the Maryland Consumer Rights Coalition, and she is a volunteer with the Maryland Volunteer Lawyer Service. And so we're excited to have her here today to talk to us about bail bond defense.
Thanks, Amy. How do we get to the next one?
So you can use the arrows to go. Or you can try now.
Okay. Okay. Well, good morning, everyone. The area of bail bonds is an interesting one because there are a lot of really sleazy players involved. So it can be fun and a little bit scary in this area of the law. There are several statutes and rules that govern bail bonds. The ones that are listed here are the Maryland Annotated Code Criminal Procedures, which just talk about the necessity of bail bonds and how they work, and that starts at Section 5203. And then Maryland 4217 is a little bit of the nuts and bolts. Anybody who has been paying some attention knows that bail bonds have been in the news recently because there has been a movement that the use of them is unfair. It puts people in jail essentially because of their inability to pay. We tried to revise that, and there is a new rule out there. It's my understanding, I think it's being challenged in the court, but the legislature just passed it to go into effect on July 1st. So Chelsea's going to talk about that for a minute.
So it's actually the Maryland Court of Appeals took up this issue when Brian Frosch really started challenging it, and the basis was that cash bail is unconstitutional in its previous form. So now courts are required to consider a defendant's ability to afford bail when setting the terms. In addition, this can be challenged by an attorney representing the defendant starting July 1st, 2017. So there hasn't really been a lot of time to study what the effect of this is, how often judges are actually considering the ability to pay or not. So it's unclear how this may affect the defense of bail bond cases like the ones we're going to talk about today. But either way, most bail bond contracts give the bail bondsman 10 years to sue defendants and signatories to the promissory agreements. So I'm sure it's not going to change anything for the foreseeable future as far as how many cases we're seeing against people who sign bail bonds.
Okay, thanks, Chelsea. So what we're going to do today is we're going to go through some nuts and bolts of what to look for in defending these cases, and then we're going to give you some examples. We have some actual motions to vacate that we filed, and hopefully they'll be helpful too. Okay, so the first thing to look for, and this was actually the subject of a recent class action that we filed, is just like the debt collection companies, a bail bond company has to be licensed, and it has to sue only in the name that it's licensed under. So if somebody is called Easy Bail Bonds LLC, they can't just sue under bail bonds. And that sounds like that's a really minor distinction, but it's a huge legal distinction. So you want to look for whether or not they are using the right name, and then just check online to see if they are appropriately licensed. And here's the beauty of that, is that unlicensed judgments are void, not voidable, which means that if they've gotten judgments over the last 10 years, you can get rid of all of them. So it's hugely important and extremely effective if that can be done. And just sort of a little aside, I don't know if any of you have followed the Finch versus LVND case, but that was on the issue of void judgments for debt buyers and resulted in a $36 million verdict in Baltimore City, currently on appeal. So these are important things to look for. What the rules also say is that you can charge a person, if you're a surety, you can charge a person 10% of the bail amount or $25, whichever is greater. So if you have a bail set at, say, $250,000, then what you need to charge them, what the bail bondsman is required by law to charge them, is 10% of that, or $25,000. And where most of the problems arise is that people can't pay. Most people don't have $25,000 in their pocket, but they're desperate to get the person out of jail. So there are promissory notes and confessed judgments and partial payments and verbal promises and all sorts of crazy stuff that usually is what causes these, not only these lawsuits to arise, but your defenses. Okay. How do I do this? Okay, so here are some things that bail bondsmen should not do and often do, and present good defenses if someone comes to you and they are being sued for a bond. First, bail bondsmen, we always argue that bail bonds are considered consumer contracts. Now, that is not 100% clear. I don't believe it's been challenged specifically in the Maryland appellate courts. And if it is determined that a contract for a bail bond is not a consumer contract, then a lot of what we're telling you today sort of goes out the window. But not all of it, but some of it. But it's case law in other jurisdictions, and we have been successful in arguing in trial that these are consumer contracts. The reason that's important, as we'll talk about in a little while, is that that gets you into the Maryland Consumer Protection Act, Maryland Consumer Debt Collection Act. So all of those statutes that are so powerful would not apply if a bail bond is not considered a consumer contract. But for purposes of today and for the arguments we've made, it absolutely is. So under the Consumer Protection Act, you cannot have a confessed judgment in a consumer contract. So if the bail bond says, you agree to a confessed judgment if you don't pay, not only do you have a defense to that to kick it out, but you also have an affirmative claim. Usurious interest rates, rates beyond 24% in Maryland are considered usurious. So we have one contract where they're talking about 26%. Also, if they add additional charges like Chelsea's explored that could be considered part of the interest rates, that can be problematic. Excessive or unsupported fees. Well, we're going to charge you, if you fail to pay, we're going to charge you attorney's fees. I've seen them at 20%, 33%, 40% without any support. They should not do that. In addition, they may say in a suit, we're going to charge, administrative fees or whatever, which if they're not part of the contract should not be included. If they fail in the contract to define what a default is, so are you in default if you're 10 days late, if you're 5 days late, if you make a partial payment, that should be defined. What is very common in these cases is they'll just forge your name onto all sorts of stuff. So that's something else to be aware of. We've had clients who have signed things in blank, who have signed things that have been changed later, who have never signed things. Likewise, altered documents. They'll change amounts, they'll change fees, because what the bail bondsman's issues are is, on the one hand, they have to comply with the law for the 10%. On the other hand, they want you to pay. So it's sort of like, you know, paradise by the dashboard light. I'll say anything tonight, which is, you know, so they'll say anything to get you to sign, and then they'll just switch it all later. So Ellen got that joke. Okay. Oftentimes, some other people did too. I'll explain later for anybody who doesn't know. So there's also bad or no service, and we'll talk about that in a little while. Bail bonds cases are replete with sewer service, and the one case that we defended that I'll show you, the court said we didn't serve this person and then proceeded to allow the confessed judgment to remain and garnish wages. So sometimes the courts are as bad as the bail bondsman. Wrong names, they will go after people who actually did not sign the contract, maybe a mother or a grandmother or somebody, and then just out and out fraud. So you want to look at all of these things when you're analyzing one of these cases. Okay, so when to defend it? Obviously, as Manny said, the best time to defend a bail bond case is before judgment is entered. So hopefully the person comes to you while they've been sued. The problem is, a lot of times, again, with the sewer service, especially if they try to use a confessed judgment, they won't do that. So after judgment is entered, the normal judgment rules apply, which is, 30 days to file an appeal, unless it falls within the exceptions of, fraud, mistake, irregularity. We talked about void judgments. But in addition, if they get a default, you can challenge it within 30 days after service. So you can have a judgment that is 10 years old, and the person comes to you, like my client did, and said, I'm trying to buy a house, and I've got this judgment. And if you can challenge service, you can challenge the judgment whenever, because you have 30 days from service to challenge it. And if they were never served, that 30 days never starts ticking. So that's how we won the one case that we had and turned it into an affirmative claim. And so it's just something to keep in mind. Even if you get a judgment, obviously you can save your client from collectability. Don't forget the exemptions. I believe it's up to $7,000 in a bank account. And of course, garnishments, there's a whole set of rules that are required for garnishments. And if they don't follow them, such as the monthly reporting, garnishing the right amount, then you may be able to help your client even if there's nothing you can do about the judgment. Chelsea, did I forget anything? Okay.
Oh, I want to mention just one quick thing about the 30 days after service. And it can be really helpful to look at case search to kind of figure out, because the client may be telling you, I just found out about whatever this bail bond is or whatever the kind of debt it is, but you can go back and look and say, did anyone ever garnish your wages? I see there was a wage garnishment that you might have received notice, or a bank garnishment you might have received notice of, or something. And so you can kind of figure out if there's something in the record that on its face maybe the client has forgotten about or whatever it is. So it's important to just do a little bit of fact checking.
Thanks, Amy. Okay, so this is, again, how you fight back, and I'm jumping a little ahead. These are the affirmative claims that we use if we are successful in defending one of these or getting a stay. The Consumer Protection Act, that by illegally trying to collect this debt and making misrepresentations, there are violations of that act. Also, as Manny talked about, the Maryland Consumer Debt Collection Act, common law fraud, and the Fair Debt Collection Practices Act as well. One of the things that we look at carefully is the lawyers who are bringing these actions, because although a bail bondsman may be the original creditor and therefore Fair Debt Collection Practices Act doesn't apply, their lawyers are subject to the Fair Debt Collection Practices Act. So if the lawyers are doing things like filing the cases with the wrong amounts or trying to enforce a confessed judgment, then you have claims against them. And it's not uncommon for a bail bond company to not have many assets. There are a lot of fly-by-night bail bonds companies, but their lawyers will generally have insurance. I have no problem suing a lawyer if they're getting judgments against my clients illegally. So that's something to keep in mind. And then if you see pattern behavior, again, something like suing in the wrong name is a pattern. Suing for wrong forms that are used, even sewer service we were talking about could be pattern behavior. So look for that. Oh, not yet. Where are my forms? Sorry, you don't get a break yet. Okay. Okay, so with all of that said, what we wanted to do is go over some of the forms that we've actually filed, some motions we filed, and you have these in your materials, so hopefully they'll be helpful. We did decide to exclude the names of both our clients as well as the bail bond company. Some of these were subject to confidentiality, and we also didn't want to mess with that, but their name is Legion, I will tell you. So, and I did keep it. I have to tell you this. I did keep my client's name, Angie, in it. She is a repeat client, and I love her. She's a very feisty woman, and one of our cases where she was netted a fee that I bought a really nice Gibson Les Paul guitar, and so I named it after Angie. So I have warm affection for Angie. So Angie got served in a case and for a bail bond that I think she had signed for like a nephew or a cousin or something, because it's not uncommon for people to just drag in all sorts of family members. You know, Sonny's in jail. Oh my gosh, everybody has to help Sonny out, and so all sorts of people are on these bail bonds agreements, which you'll see. So they filed suit against her, and she filed a notice of intention to defend, filed a motion to continue, and the trial date was postponed. She didn't go to trial, and judgment was entered against her, which on first read you're like, oh, already a judgment, I'm sunk. But not necessarily. Sometimes you can fight all sorts of things. So we fought this, and we said that she was confused because the trial date was changed. And also, we took a look at the court file and the affidavit judgment. And again, sometimes the courts really screw this up. And so on the one hand, they entered affidavit judgment, but then it also said in the next line that affidavit judgment was denied because of illegible signature. So what the heck is that? Is that judgment entered or is that not judgment entered? So there they entered it, and we challenged it. So we said she signed a promissory note and indemnification agreement based on a promise that the contract would be superseded by another contract to be signed by her brother, the other defendant, upon somebody else's release from jail. And instead of doing that as promised, there was a joint and several agreement leaving defendant at risk for liability. So we argued fraud in the inducement, which, by the way, before district court, we think is very difficult to prove, but she paid us, we promised her we were going to fight it, and we fought it. So, and then we also threw in there that her brother had been paying on the bond, and therefore the judgment was incorrect. So we requested that the judgment be vacated. Now, let me just do a little commercial about district court judges. How many, I don't know, people on the TV, but how many of you have tried cases in district court already. Okay, so you know, and correct me if I'm wrong, there are some judges that when you walk in are very happy to see you. And they're like, oh, thank goodness these people finally have somebody defending them. There are other judges who look at you like you're a real pariah. You know, the bail bond attorney and the debt collection attorney are there every day. Hey, Mo, you know, how are the kids? And didn't you love that game last night? Let's have dinner next week with your wives, you know. And I go, ooh. So it's not always guaranteed that the judge is going to like you or see it your way. And Manny was talking about that, and that's important when you're discussing options with your client. At the same time, you know, as much dust as you can raise to protect your client, don't be afraid to raise it, because what have you got to lose? She's already got the judgment against her. So we filed this, and what happened is the court agreed to vacate it, and then that's just our petition to file it. Yeah, so this is what they had gotten a judgment against her. Again, part of this had already been paid, but she got it for $2,400 plus pre-judgment interest and attorney's fees. And so we got that kicked out. And then, this is something new. And then when we went to court to argue the underlying case, the bail bonds didn't show up. So we were able to get a dismissal, which you always want a dismissal with prejudice. So that's why it pays to fight. So when she came to us, she had already had the judgment against her. We got that wiped out. Now, the question became, do we file an affirmative claim? We decided not to in this case because the bail bondsman was one of those fly-by-nights, and so we were concerned collectability was probably not going to be great. Chelsea, you want to add anything?
No, I'm not agree.
Okay, so this is our confessed judgment case, which I alluded to. My client, Jeffrey, he came to me, like I said, he was trying to buy a house, and it was sort of a sad story. His dream in life was to buy a house, and because this judgment was on his record, and it was a significant amount, it was over $23,000, actually almost $30,000. Because this was on his record, he couldn't, they would not give him financing, and in fact, he never did get financing for that house. We screamed and yelled and wrote letters and filed things in court, but by the time we were able to get it corrected, he had already lost the house. So it was a really kind of a sad case. But here's where we're going to show you, and this is what I was talking about earlier. Here's case search. Okay. See where it says service returned, no forwarding. That was service on my client. So they put the confessed judgment against him anyway, and under the rules, he had 30 days to challenge that. They never should have used the confessed judgment in the first place. I guess that's the end of it. So we went ahead and moved to vacate it based on that. Now, this one, I'm going to go through it because I want you to see the attachments to our motion to vacate. We included numerous ones. You want to make your case as strong as possible because, again, we have had judges who were openly hostile to us who have granted our motions despite the fact that they thought we were big pains in the neck because the law was just so strong. So you want to talk about that thing with Matt, Chelsea?
With the landlord-tenant?
Yeah.
So recently, I mean, just to kind of piggyback on the hostility, and while it seems like we're complaining about it, it is a real issue that we always discuss with our clients because it is not only do you have the normal lawyer challenges of just what are the defenses, what are the claims, but you also have to overcome hostility that we face in the courtrooms all the time. So we recently had one of our attorneys go and fight a landlord-tenant case. It was actually in the failure to pay rent action in rent court down in Anne Arundel County, and clear violation. The landlord was trying to collect only for a water bill, and the contract actually said that the landlord would provide for the water, so the tenant wasn't even responsible for paying for water. and yet here the landlord's trying to evict the tenant just based on water bills. So our partner said, you know, we're here to fight this case, and the judge said, so we're going to have a trial over $300, and was very upset that he had to listen to, you know, a trial and not just grant, you know, judgment in favor of the landlord, because rent court is notorious for, I think it's only a few minutes of
what happened? Did they attach the rent to the water bill, and the tenant paid the rent and left the water bill? That's what.
Yeah, so the client was actually up to date on rent. There was no reason to bring the failure to pay rent action. It was only the water bill. But the landlord doesn't usually always say that to the judge. The court, they'll just say rent is due and owing as in the amount of, you know, $300, because a lot of the contracts deem rent as utilities, fees, late fees, court costs. So they'll say to the court, oh, this is just rent, unpaid rent, and it was really one water bill, and the landlord had no right to even bring to charge the tenant the water because it was supposed to have been included as part of the leasing and the rent. So he did prevail, but it was very difficult, and the judge ended up apologizing to the agent who was there on behalf of the landlord that they had been put through the ringer, and it had really been sandbagged.
Yeah, the poor landlord was sandbagged.
And then our partner proceeded to watch the same things happen to multiple people who were there who were unrepresented at the same place, and the judge went ahead and entered judgment for the landlord, even though he knew that it, you know, was probably illegal.
So, you know, the people, there's very little sympathy for the people who owe these debts and are getting kicked out of their houses. But this is, you know, we can rail against it, or we can accept it as a reality and do our homework and try to change it, because, you know, Matt Bocci was able to keep that woman in her place. So it matters. What you do really matters. Okay, so this is the motion that we filed, and it's kind of long. We said to confess judgment upon, and at this point, you know how you win a $1 million case? You screw up a $2 million case. Mm-hmm. So there were things here that I missed. I mean, for example, I missed the confess judgment on its face was illegal here, but there were other things that we had. So, oops, what happened? Okay. So what happened in this case, just to give you a little background, because I'm not going to read the whole thing, my client, I believe, had a son in jail. And so when it came time to get the bail bond, they signed a contract, and I believe they paid $5,000. And they thought that was all they needed to pay. And then the charges against him were dismissed. So he thought, well, if the charges were dismissed, I didn't really need to pay this bond anyway. So he just let the whole thing go, and I think the grandmother had come up with the $5,000. And then all of a sudden, out of the blue, he gets a call that says, you owe me $3,500 more. So $3,500 more, okay. So he goes to meet, there was this big story that he goes to meet this guy at Calvert Hall where his son was a student, and the guy gives his son a T-shirt, and he says, all right, now you owe me $3,500. He pays the $3,500, and he gets a document which will show you. It says, well, it was $25, you paid $35, now you still owe me $16,500. And he said, well, I don't owe you $16,500. He said, yeah, I know, I'm just doing that for the boss. Meanwhile, he was the boss. So we actually had a case where the client signed a document saying, well, no, he didn't sign it, but it was a receipt given to him saying, you owe us $16,500. So he pays the $3,500, thinking that's all he has to pay. He goes away, and then all of a sudden, he finds out years later that there's this confessed judgment against him for $16,500. So he starts by saying that he was never served with it. That if he had been served with it, because you also have to claim you have a legitimate defense to the claims, that, you know, there was fraud in the inducement, that there were, you know, we talked about the conversations, what happened in the parking lot, had he been told that $3,500 was insufficient to cover the bond, and that he would really owe $20,000. He never would have agreed to pay anything. You know, he repeatedly said to me, "I want to let that kid sit in jail for $20,000." So it's like, there's no way. There's just no way. So then we took a look at the documents, and you know, my client was like 350 pounds, and he had a certain income, and the form that the bail bondsman filled out was all wrong about all that stuff. So we challenged that. There were forged signatures on documents. I mean, we had all sorts of stuff. So we described all of that, and you know, here's the standard law. This is our argument. The confessed judgment wasn't really signed. Oh yeah, we did. Look, I'm smarter than I thought. Okay, we did bring it up. Sorry, we said it's interest rate, attorney's fees are in excess of the legal rate, not supported by affidavit. Keep that in mind. They just can't throw attorney's fees on there. And so for all of these reasons, the judgment should be vacated. And you always put in a form order. So here are all our exhibits to that. First, we had an affidavit from him, and he testified, which, by the way, an affidavit you can't use in trial, but you can use in a motion. So it was perfectly legitimate to have him sign this affidavit. And he tells the whole story. You know, I thought the transition was done. They never attempted to contact me. I was never served. My son was not living at the place where you said you served him. By the way, the son never retained me because the son was sued too. And while we did get our judgment vacated, the judgment stayed for the son, which is a tragedy. But you can't represent people who don't sign the retainer agreement. So we were willing to help him, but he never showed up. Okay, so here's this document. See, it's 8/15/11, received from $3,500, the amount of the account, which is the $20,000, amount paid, a balance due, and then Sean signed it. My client said there was no way. Somehow that document was in his file, but you see he didn't sign it, and he said, I would never have agreed to that. So Sean at some point came up with that. All right, there's the receipt for the $3,500, and you see it does not include any balance. The balance is forward, so that lends credence to our argument. Okay, this is typical of what a bail bondsman will have the client fill out. So here's all his information. He said, that wasn't my weight, that wasn't my height, that wasn't what I made, that wasn't where I worked. And what he said is he signed a document in blank, and then they filled in the rest. So we included that. Oh, and check this out. This is not unusual either. So nothing is filled out except his name here. Like, well, this is what you owe me, but it's not filled out. I mean, look at that's just kind of crazy, isn't it?
Question for you, Jane. Was that
Sure.
promissory note, what you just showed us, where the client signed in blank? Was that something that your client had a copy of, or was that something that you got in discovery? Or
I think it was attached to the complaint against him. Is that right, Chelsea? Yeah,
Probably.
I think so.
And there is, Maryland Insurance Article 10-309 says that if there's an installment agreement, that all those things have to be filled out. So you have to provide the total amount of the bond, the amount of the down payment, the balance owed, the amount and due date of each payment, the total number of installment payments required to pay the amount due. So make sure if you do see any kind of installment, though, which means the client's going to pay over time, that all of these information is included in the note.
Otherwise, it's a violation.
Well, otherwise, yeah, I would argue that they can't enforce it because they didn't comply with the statute.
So to cover all of his tracks, too, the bail bondsman sort of did this two different ways. First, he has a promissory note for the full $250,000 in case the guy jumps bail. And then he also had a separate one, I don't know if I have it here, for $25,000. So we had him sign both, which was, you know, kind of crazy. So what happened in that case is we got the judgment vacated, and I think we got the case dismissed with prejudice, or we moved to stay it, and then we filed an affirmative claim, at which point the bail bondsman came to us and said, I'm just a kid, I'm going to have a baby, and I don't have any money, and please go away. And so we had trouble collecting from him, but the lawyers should have never gone after him either. And we ended up getting a very nice settlement from them, which paid most of our fees and got our client satisfied. So, you know, nothing is ever as much as you'd like, but it was an impressive amount given the shape he was in when he came to us. So that's what you can do with these cases if you sort of do your homework. Here's another one. This is one that's an example, just to give you an example of how they file these. This one we were able to defend on the ground that the name was not the legal. They sued under a name that wasn't a legal name, and that they also weren't licensed. So there is one particular debt collector who, I think he stopped it because we sued him about 3 times now for it, but just uses whatever name he feels like.
The attorney.
The attorney. So he uses, and he admits under oath he uses the name for convenience sake. So if you see something like that, you know, don't just assume that name is right. So that
you can check. Did Manny talk about? You check SSTAT, what name they're licensed under SSTAT, the State Department of Assessments and Taxation.
So you can take a look at that. I'm not going to go over it, but this is a typical complaint under a bail bond. And interestingly, this is a requirement under FDCPA, so they just like stick those things right in the lawsuit itself, which they can do. I mean, they don't have to do it beforehand. So they say here it's an attempt to collect a debt. And there's the Servicemen's Civil Relief Act. By the way, we had a case in our office where, it's still going on, where the client was in active military, and they attached this thing that said she's in active military, and they sued her anyway. So we have included an affidavit that she was not in the military. So that's a big no-no. We filed an affirmative claim for that. So here they, just to show you how they will list this, there's the bond fees, the total payments, the remaining balance, overdue balance, net payment due. I don't think there's anything illegal about that.
No, and actually there's the statute I cited earlier, 10-309 of the insurance article, says that the bail bondsman must keep and maintain records of collection attempts. So if you do have a case that you're defending and you get it early enough that you can issue discovery, you want to make sure you ask for all records of collection attempts. And then if they can't produce anything and your client has records or has communications from the bail bondsman, then you can either challenge the fact they didn't provide it, or you can say, well, the law states you're supposed to maintain records, and use that how you will.
Okay, and there's an example of the indemnity agreement.
This bail bond had at least 5 different people sign, so there were at least 5 people who were on the hook for this one bail bond. And our client later explained that he was told when the additional people signed that he would be taken off, and of course he was later sued, and his wages were garnished.
Right. So there is a tremendous amount of fraud in the inducement. People are desperate, and they'll just tell them anything. So if you can, you know, yes, we'll take you off. No, you don't really owe it. Somebody else is going to pay. This is all you owe. So it is. They can be fact-intensive cases. So here is the here's the form they have people fill out, and I thought this was interesting. They look at all they want to know. They want to know the children's names, the mother's names, the father's names. Like, why the heck do they want to know all that? And then they have the different indemnitors, indemnitor 1, indemnitor 2. Okay. And there's I just thought this was, the client did this by himself, right, Chelsea? Mm-hmm. Okay, I do not owe any money. I asked to have my name pulled off of the bail, and I was told that my name and, what was that say? I forget. I don't know. Mm-hmm. And something would be, so, you know.
And he did show up and attempt to defend himself on his own and was basically told, you know, well, they have a contract, so you owe the money.
There's attorney's fees of $750 cost. I know our mantra in the office is, with us they barely have a chance, and without us they're completely, you know, they're completely at a loss. So, so there you go. Okay.
So what was the argument that prevailed in this case? Was it the fraud and inducement?
No, it was that it was not a real company.
Right.
And then even the company that it was supposed to have been, they had let their registration lapse or failed to keep their business status active with SSAT. So it was an inactive business, and there's case law that says you can't bring lawsuits if you're not active, you know, an active business with the state. So we were able to vacate the judgment and then get something for our client as well.
If you have a simple, straightforward defense, I find that that's often better than a fact-intensive defense, because if it's somebody's word against somebody else's word, it's much more difficult to prove it. I mean, you can build that case, but you're not licensed, therefore you don't have to have the legal right to collect the debt. Is just so much easier if you can do it that way. So the way our firm works, and again, I don't know who all is here on our call, we are sort of set up where we are looking for the affirmative claims. We don't want to just say to people, go away, because our view is that for every one person who we're able to help, there are probably 1,000 who are being illegally collected upon, who we can't help. So we try to find as many affirmative claims as we can and say, you should not be doing this to these people, and we want to teach you a lesson as to why you shouldn't. And that's why we touched on the stay in Manny's presentation. Our goal is, as much as possible, get the darn thing out of district court. There's already a judgment. You can't do that. You have to be in district court. But if we can spot the affirmative claims, file the case in circuit court, and then move to have it stayed in district court. I think there's only been, how many times have we not been successful in that, Chelsea? 2?
I can only think of one. But I don't
right. Well, one happened to me a couple weeks ago before Judge Katie O'Malley. I was very upset about that. That's the only thing, and that was a landlord-tenant matter, but that's the only one I can think of. So that's all we have, unless there are any questions or more comments.
I have a question for you. Can you talk a little bit about that you had a slide kind of mentioning pattern and practice? Can you talk about that a little more? Like, what kinds of patterns and practices most often, and how are you able to help the clients and in those situations? Have you ever done any kind of class action with these? What does that look like?
Sure. This case that Chelsea just talked about, the one where the company was not registered, we filed as a class action, but ended up settling on an individual basis. So we felt like the failure to be properly licensed and use the correct name is clearly a pattern in practice. And what we do is we'll go on SSAT, or now there's the scraping method that, case search. So you can tell how many times they filed suit under those certain names. I think a confessed judgment is a pattern in practice. The problem with it is it's hard to if they just put it in the contract, because the Consumer Protection Act requires actual damages, unless the person gets a judgment against them under the confessed judgment provision, you have a violation, but you have no damages. So those cases are hard. I think if you're seeing in the forms standard interest rates, standard claims for attorney's fees, all of those things would be pattern and practice. Sometimes you can see them off the bat. Sometimes you need to do discovery in the underlying case, and then once you do discovery in the underlying case, you find that there's a pattern and practice based on that.
Any questions from the live audience here about bail bonds in general or about some of the cases that they've brought? I know I want to just mention, you know, we do, MBLS does this a clinic, a brief advice clinic every Tuesday morning in the district court, and these are cases that we see pretty often. And I can tell you, after doing consultations with many defendants in bail bonds cases, that I don't think that we can stress enough that there really is, if it's not outright fraud, it's just, you know, just misleading these folks who are signing these agreements. The story that I hear almost every single time from these clients are that I went in to sign this bail bond, they told me that I needed to pay this much up front, and then if the person showed up for trial, I was good. Mm-hmm. And that's almost never the case. So these bondsmen are relying on the fact that the people coming in to sign these bond agreements don't understand that 10% rule, and the fact that they're really only putting down 1% and they still owe another 9% regardless of if the person shows up or not. So they leave that information out and rely on the defendant's lack of knowledge to get them to sign these documents and then later come back and get them for it. That almost every single defendant that I've talked to has that exact same story. So that is most definitely a pattern in practice. You know, whether you can hold someone accountable for that is tough because, like Jane's saying, it can be, you know, their word against the bondsman's word. But just be aware of that, and the fact that I've heard it almost every single time I've talked to someone in these cases leads me to believe that it really is happening. It's not just someone saying, well, I didn't know. They really didn't know, and the bondsmen are not trying to correct them because it's to their advantage to not correct them.
Right, because they may be like Jeffrey and say, well, wait a minute, if I'm going to owe you $20,000 and not $3,000, I'm going to let the guy sit in jail. I mean, seriously. And, you know, fraud cases, it is not true that fraud cases are impossible to prove in Maryland. They're not easy, but we have gotten fraud verdicts. And in a case like that, even on a verbal exchanges, what you need to do is you need to get 5 or 6 people to all parade into court and say they told me the same thing. And so those can be really fun cases to try, but you need to do the footwork to get the witnesses to all say the same thing.
I'm going to piggyback off of what Jane and Ellen are saying. I have had both clients and, in fact, bondsmen tell me that many of these bond contracts are signed in the middle of the night on the hood of a car, and you know, the bondsman drives out to maybe in his vehicle with a pen painted on the side of it or something like that, to wherever they can meet this person, and sign this contract, and they tell them whatever to get them to sign it. And then they do. And the really unfortunate thing is that, you know, studies show that if somebody is not in jail when they're awaiting a criminal trial, they're actually far more likely to prevail in terms of that criminal trial. That when you can participate in your own defense, you do better. And so the difficult, this is obviously a difficult thing that these families weigh when they're trying to figure out what to do. But one of the reasons why you see so many names on these contracts is because the bondsmen are looking for somebody that they can potentially tarnish.
Do you want to talk a little bit about body attachments?
Well, sure. So body attachments are, it's like debtor's prison now, which we're not supposed to have in Maryland or in the United States, sort of out of Dickens' time. But essentially, even though under normal circumstances a person can't be thrown in jail for owing a debt, if they are supposed to do something like answer interrogatories, or if there's a post-judgment interrogatories, I think, are the most common. So after trial, after judgment, you have post-judgment enforcement procedures. And so some of those are, you can send them questions, and you can ask the person to come in and answer and have an interview where they actually, oh, thank you, Chelsea, that's the word I'm looking for, oral examination. And even though, again, it's a monetary debt, if they don't show up, then the collector can say to the judge, well, they didn't show up, please get me a body attachment. And then the sheriff goes out to their house and actually puts them in jail for failing to come answer your questions pursuant to oral examination. And so at that point, the bail may be set at what they owe you. So it's an indirect way of getting the collector getting paid by throwing you in jail. Did I explain that right?
Yeah. So I think the thing to point out about this is that bail bondsmen are one of the most prolific users of body attachments. There are a couple of there is one particular relatively large landlord that does this. A couple of smaller landlords, a couple of smaller other kinds of debt collectors, but bail bondsmen use this pretty prolifically. The court could conceivably say that this is a penalty for failing to obey a court order to either answer the post-judgment interrogatories or appear for the oral exam. But the fact of the matter is the payment doesn't go to the court for failing to appear in court. It's not a punishment for it, and that makes it not a punishment for failing to appear in court. It's a payment that goes directly to debt collector. It goes to the bail bondsman.
And some of the problems we've seen with it is, again, they're supposed to be served with kind of these, you know, the post-judgment, whatever they're trying to get, if it's the oral exam or whatever, and they're not served, and so they don't know that there's a body attachment out there, and they'll just be like driving their car, and the officer will pull them over and say, you got a broken taillight, and then when they run their name and they find out there's a warrant, the person is arrested. So the person has no idea that this is even a potential for them, and they end up in jail. And I don't know if they've changed it, but the last time I heard was they're kind of in this like no man's land in jail where they don't usually get like a hearing or until it's figured out what to do with them. But I don't know if that's changed. The last I heard was they kind of sit there until the judge figures out what to do with them.
The worst case scenarios are when somebody gets picked up in the evening or gets picked up right before a long weekend. They can wind up spending the weekend in jail. And, you know, if you are required to be at work on a Saturday and you fail to show up, you could lose your job. And obviously there are a lot of other consequences for somebody that was not necessarily expecting to spend a weekend in jail, them having to do that, issues relating to custody of children, issues related to just kind of the mental anguish that somebody might experience in that kind of situation because they weren't necessarily expecting to happen. But what happens is that when they get sorted out, they will get taken before a judge, and either they might, and the very fact of the matter is whether or not a body attachment gets set in the first place and whether or not the person actually has to pay the money over is not necessarily does not happen the same way every time. Whether the body attachment gets set, what the amount is that it gets set in, and whether or not the person has to pay it when they finally get in front of a judge and are ordered to pay it, it all very much depends on who you wind up in front of, who the defendant winds up in front of. And so it might be possible that they will have spent the weekend in jail. They might say, I can't afford to pay this, and then they would just be released. Except the person just spent the weekend in jail and shouldn't have.
Amy, isn't there a movement there to get rid of that?
So getting rid of body attachments is something that certainly we are concerned about. There was some attempt at some legislation, the most recent legislative session. It wouldn't have taken away body attachments, but it would have changed the direction that the payment would go. So if the body attachment was ordered, the person was picked up and ordered to pay, the money wouldn't go directly to the bondsman or to the debt collector, to the plaintiff. It would instead go to the general fund or to the court or something like that. I think to the general fund with how it was written. And the bail bonds lobby soundly defeated it. They fought it and then won. Obviously, there was a huge fight during this legislative session about bail in the first place because the bondsmen were apprehensive about what their bottom lines were going to look like when this new rule took effect, which only just happened. It's already believed that there's going to be another fight over the same situation this coming year in terms of what how bail is calculated. But there is still some momentum to potentially try again to do something about body attachment. Exactly what form that's going to take, we're not sure yet, but it's something that we're working on. And if that's something that you're interested in knowing more about or being involved in, you can certainly contact me and let me know. Yeah, I feel very strongly about this.
And I would just say that in general, defending bail bond cases is a little different in that the attorneys are very aggressive, that they're not usually willing to work with you as far as payment arrangements, as far as affordable payment arrangements for your clients. It's very difficult. There's a lot of back and forth. I had a attorney recently say, you know, I'm not going to accept that because I can garnish her wages for much more than that, and I will garnish her wages. And this is someone who works for the janitor for the school system. So, I mean, they are just generally more aggressive and less likely to work with you than other attorneys for, you know, debt buyers or different creditors. So just keep that in mind when you're dealing with them as well, that it's generally more difficult.
Which is why they're so much fun to sue.
Since we have a few minutes left before we take our lunch break, I just had one last question for you guys. Concerning sewer service, you guys kind of touched on that, and this is an issue in many debt collection cases, but I think particularly with bail bonds cases. Can you guys kind of talk a little bit about what that is and how someone can kind of determine whether this is a sewer service issue and what to do about it?
Well, sure. So did you want to take that?
So you can.
Okay. So sewer service just means they weren't really served. They said they were served and they weren't really served.
They threw it in the sewer.
Yeah, that's where the term comes from. So to be served, you either need to be signed for certified mail, which the person themselves needs to sign for it. That's registered mail, certified registered. Or you need to be served personally, as in someone handed it to you, or a family member or an adult living in your house, to get that right, needs to accept it. Those are okay too.
Somebody of suitable age.
Right. Okay. So you can't give it to a 2-year-old.
Right.
So
Hopefully a 2-year-old's not answering the door, but
right.
Never know.
So what happens is people say, I was never served. Like my client Jeffrey years later said, I was never served. So that failure to serve is a defense to getting rid of the whole judgment. Now, I've had tragic cases. I had one, made me so mad. My client was sued for like $65,000 for a business deal, and he was never served. His ex-wife, who didn't really care for him, actually gave deposition to say, I was living in that house. He was not living in that house. He was not, I didn't really invite him to the house or even the driveway. Served, and you know that judge still ruled against us. Oh. So it is an unfair world out there, but that's sewer service. The problem that we have with sewer service, and maybe somebody else can address this, is that the process servers aren't necessarily subject to the debt collection and consumer protection laws, and it's also difficult to show that the whoever the creditor is or the debt collector who hires the people doing the sewer service are liable for the acts. So you have these really scummy, awful people running around ruining people's lives, and it's hard to get at them until the law changes.
It's also not uncommon to see, I've seen people in the clinic who say, oh, these papers are just leaning up against my door, and it was the lawsuit, and then the process server says, I personally served them. I had one just recently, and we were successful in striking service, but usually unless you have an app, we fix it by having an affidavit from the client and some other documents showing they were not living at the time. So if you have a lease or some kind of document showing a utility bill, something that they were actually living somewhere else at the time, that's helpful because judges like to see documentation rather than just your client saying, I wasn't served. Those types of things are helpful if you have other witnesses who say, no, they weren't here. We've had people who were living in different states, and we can prove they were living in different states, or receipts showing they were in a different place at the time. Those things are all helpful in trying to strike service or to vacate a judgment based on sewer service. But it can be difficult.
And there is case law, I believe, that says the person saying I wasn't served is not good enough. So you may want to bring in a witness. In addition to the documentation, you may want to bring in a witness, although if there's a certain Mr. McNasty in Baltimore County, he's not going to buy it anyway. But
yeah, I mean, and be prepared when you go in. If you're going to challenge service, be prepared to get pushback, because you will get pushback. What I generally see, at the clinic, defendants aren't usually prepared, to challenge something like that. They may know they haven't been served, but when I see them, they're appearing and at the affidavit judgment hearing date, they think that it's a trial, and it's not, and so they're not always prepared to challenge service or even know that they can do that. So if you're in that sort of a situation and you're trying to help them, and you go before the judge saying, well, judge, they weren't served, and the affidavit on its face says, oh, well, I served this person, the judges generally in that situation aren't going to buy it, and they'll say, well, the person's here now, we'll just give them a copy of the complaint, and we'll move forward.
That's common too. Yeah.
Very common. And the other thing that you will hear, hopefully that you will hear is, okay, well, we'll have a motion on, striking service on the trial date, before the trial. So that's hopefully what happens, and you can kind of prepare and gather those things to help challenge that on the trial date. But, I've had situations on the affidavit judgment docket where the judge really pushes back hard. And, in one instance, I said, Judge, the defendant hasn't been living at this address for a few years now. The judge then demanded to see my client's driver's license, and the fact that it was the family home, that's the address that was on the license, said, well, one, I don't believe you, and two, did you know that it's illegal and there are criminal penalties for not changing your address? And basically insinuated that my client was a criminal for not changing their address on their driver's license. So you do face opposition, but if you can get a motion on it and be prepared and bring witnesses, bring the affidavits, bring the proof that they're not living there, I think judges it's a lot harder for judges to ignore that.
And I have cited I think it's Gwen v. Gwen, it's G-U-E-N versus G-U-E-N, that says that actual knowledge on the part of the defendant does not cure the problems of service, that's a due process consideration. And successful in the past when I've brought that up, because I have gotten the same, well, they're here now, they know about it. That case has been helpful in the past.
And interestingly, in that Hansen case we were talking about on the FDCPA, Judge Gorsuch starts out by saying that the repo man is subject to the FDCPA, which is like, wow, that's really, because there's a lot of case law that says he's not. So I've been thinking, based on what Judge Gorsuch told us, that maybe not only the repo man, but also the process servers maybe they can be subject to this. I think it's a stretch, but you grab anything you can grab because you really don't know how it's going to go down.
Yeah, and I think this is still a kind of an emerging area of law for consumer defense. Debt buyers, people have been suing debt buyers for years now, and looking at the complaints and the abuses from a few years ago and looking at what's going on now, you do see a lot of improvements. That's not necessarily the case with bail bondsmen, because I think even more so than in some debt buyer and consumer cases, the folks that are in these bail bonds cases are really at the bottom of the rung as far as resources go. So they're almost never represented. They already are operating from a lack of knowledge, when they sign the bond. So it's very, very, very easy for abuses like what we've talked about to happen. And there haven't really been a lot of attorneys going in and defending these cases. So there's a lot of business out there. There are a lot of people that need help, and it's really an area where you can if it's something that you're looking to do. It's a really good area to start looking. Okay, and so I think are there any other questions or comments?
Or if people on the phone want to type a question in, that's also welcome.
Do you notice that there's like a bias in court? I mean, against, because essentially the family, there's going to be assumption, okay, you're the family of the criminal, and there's got to be or assume there's some stigma, and bias in the courtroom.
I think there is a very sad bias in the court against all of our clients. Somebody told me who was running for judge that when a person puts that robe on, they automatically take a step to the right. That most judges cannot relate to what our clients have been through. And unfortunately, it seems like most of the people who are named judges are either coming from like state's attorney positions or big law firm positions. Well, I think keep bringing the cases. Keep bringing the cases. We are trying. We were talking about this 2 days ago in our office to try to educate some of the judges a little bit more about the consumer issues. I think that people who do the work we do, trying to become judges. I think there's slow momentum, but I think continuing the fight is what makes a change. And I'm encouraged just what we were saying earlier. I mean, when I started doing this work, it was just common that these debt collectors would get fees and costs. And what happened is a bunch of us went down to the Rules Committee and pounded and just sort of an aside, because you do not know the impact you'll have. The Rules Committee had 8 people on it. One of them happened to be a childhood friend of mine, and the vote was like, I don't know, 5-3 or something like that. And he came after me. Yes, he came up to me afterwards and said, Jane, I had no idea what you were talking about, but I knew if you were saying it, I was going to go for it.
Yeah. So I think,
if I could just add one thing, the talking about how it's a pattern of practice is very important with judges. So if you can show that this matters not just to your client, but to all these other people, and that the defendant is doing this to a lot of people, and that's really powerful.
Yeah, and I mean, not to get too philosophical, but it's one of my favorite quotes is by the man, I don't remember his name, who was running Hotel Rwanda, and he said the most powerful weapon we have against evil is the belief in human decency. So sometimes that agrees to be really covered up, but I think if we keep pounding and saying, this is just not right, this is just not right, this is just not right, things start to shift. And I think just showing up, the Rules Committee is, I thought we were making these fabulous arguments, and the guy didn't understand any of them. It's just like, I knew you. So relationships,
yeah,
being there.
Yeah, and I would also say, too, like in these cases where you're challenging service or where you're, bringing up the fact that there was fraud in the inducement, it's because you're fighting an uphill battle, you have to be very well prepared. more so than in other cases, perhaps. Not that you wouldn't be preparing a case, but you know, having statutes, having case law, having case after case after case that supports what you're saying, and bringing that up as often as possible. I think the more that you do that, the more that, one, it's going to be really difficult for a judge to say, well, I don't think there's a basis to rule in your favor, because you've shown that there is. And two, they're going to get to know you. They're going to respect you as an attorney, and they're going to trust that what you say is true and is proper to do. So I think it's part of, you know, building your reputation, and doing that as a group, you know, with other attorneys who are doing this work.
Well, and along those lines, there's some really bad case law out there. You know, we didn't get into it, but under the Maryland debt collection statutes, there are some terrible interpretations of what that statute means, a lot of which come from either pro se clients who just got really bad results, or an attorney who tried to do it on his or her own. You know, I've been doing this for 15 years. I've been a litigator for 30 years. I will not file an appeal on one of these issues until I talk it over with these guys and some other lawyers and say, are the facts of this case and the legal issue, are they going to help us in the long run, or am I entering into danger zone? So don't try these things alone.
Yeah.
We're here to help.
Yeah, you don't have to operate in a vacuum. With all of these case types, any consumer law defense, it's a very small bar, right? So there aren't a lot of attorneys doing this work. So I think that civil justice is working on making one. If you guys are, if anyone on the webinar, anyone here today is interested in a lister, please let us know, because you know we have your emails from the sign-in, and we can make sure that you get on that list. But it's a really small group of attorneys that are doing these cases statewide. So if you want to do them and you're looking for help, we're willing to help you, because frankly, nobody's fighting for business. There's so many clients out there with claims like this and with cases that need defending that you know you're not going to be fighting over business with anybody.
Well, plus, just a little commercial, there is Civil Justice, which is created to help lawyers, small firm and solo lawyers, help these people and still make a living doing it. So Civil Justice has all sorts of really good programs out there. I'd strongly encourage you to investigate that. And also a plug for the National Association of Consumer Advocates. They're having their annual meeting down in Washington, D.C., so it's drivable this year. They have them all over the country. That organization is well worth the cost to get in. There are scholarships available for the conference, and you have some of the best minds in the entire country that are addressing these issues. There are manuals that answer just about every question you can have. So, and plus there's also the Maryland Consumer Rights Coalition, which I would encourage you to join.
Yeah. The last thing I'll say then before we take our break is that.
I have one more question.
Oh, sure. Yeah.
When do you do the clinics at the district courts in Baltimore?
So MVLS does the brief advice clinic in the district court on Fayette Street on Tuesday morning. So the affidavit judgment in Baltimore City, the docket is heard on Tuesday mornings and Wednesday mornings. So we go and we give defendants who are there on Tuesday mornings brief advice, and then the Pro Bono Resource Center also does the clinic on Wednesday mornings. So there are two days of the week that you can come and sit down with folks and talk to them.
What time, like?
I usually arrive there at 8:30. The courtroom's usually open at 8:45, and we usually begin the consultations around between 9 and 10 after 9, depending on if the clerk and the judge are there on time. But you know, we're usually out of there by 11 or 11:30, depending on the number of clients that we see there. So it is a really great opportunity to kind of just get in the fray and see what's really happening and see who's showing up. Generally, the plaintiff's attorneys are not there because it's the affidavit judgment date, So they are not on notice that the defendant is showing up to defend the case. So it's really the defendant's last chance to be able to enter a defense or challenge the case. And if they enter a defense, the case is reset for trial, and then they have to come back to court in about 30 to 45 days. But it's, you know, you'll see these issues, and you know, that's how MVLS is really able to keep a finger on the pulse of what's happening with these collections cases is from that clinic. So, and it's also a good way to find claims and to, you know, help people out and get in a little bit earlier than you might if someone comes to you on their own. So the last thing I want to say before we take a break is if you're interested in doing this work, we also take part in a consumer roundtable that happens once every other month, I believe. The next one, I think
it's once every 3 months.
Yeah. So basically once a quarter. We just had one, so the next one I believe is going to be at the end of September. But if you're interested in going to that, it's actually Avi Malik at Civil Justice is the one who kind of coordinates the meetings. So if you're interested in that, please let us know, and we will make sure that to connect you to Avi so you can come. The roundtable is just people, private attorneys who practice in this area, legal services, public interest attorneys, the members from the Attorney General's office, the Consumer Protection Division come. So it's a variety of different actors in the consumer realm. Generally on the defendant side, we've never had a plaintiff's attorney show up. But you know, people who are doing consumer defense, we all meet and talk about what's going on and maybe recent trial wins and losses and kind of strategies going forward. And that's especially helpful around the legislative session, so you know what kind of legislation is going on. All right. So with that, we will take our lunch break. And for folks who are on the webinar, we will start again at 1 o'clock.
So it's now about 1 o'clock, and so we're going to jump back into things. I'm going to start off by saying, I'm going to mention just a couple of things here. If you are on the phone, again, I'm going to mention that you should have received an email from me last night. Everybody should have received an email from me last night with all of the handouts. If you didn't, for whatever reason, maybe your firewall blocks the large attachments or what have you, shoot me an email and let me know. My email is ahennen, A-H-E-N-N-E-N, @mblslaw.org, and I will get you all of the attachments. There are some attachments, including one of the attachments that Kay is going to talk about, the interrogatories one that's available from the drop-down. If you're on the phone, if you see the handouts box, that you can potentially download that straight from there. Thank you. And I think somebody on the phone had mentioned that we could refrain from rustling paperwork or what have you near the speakers. That would be helpful. And then with that, so we're going to transition to talking about landlord, both landlord-tenant defense and also a little bit about affirmative claims, because security deposit return can be an affirmative claim. The one thing that I want to point out is that what exactly the animal of court that you are dealing with in terms of the district court will vary depending on whether you're talking about a failure to pay rent action. So in Baltimore City, that's going to be in courtroom 2. They do that docket 5 days a week. And it is a robust docket. If you're there Monday through Thursday, there are people coming out of the scenes in that courtroom. Mm-hmm. And so there are components that are important to know about the failure to pay rent docket. And then there are lots and lots of cases that we see mostly that are coming through a contract collection action. So in general, this is going to be a case where there was either rent that wasn't paid, or there was some sort of damages to a unit that the landlord is now suing under contract law to get repayment. And so with all of that, we are incredibly lucky to have Kay Harding, who's a staff attorney with the Housing and Consumer Unit at the Maryland Legal Aid Bureau. She's a former coworker of mine. I respect her immensely. So she represents people that are dealing with all kinds of housing matters, including foreclosure, tax lien. She represents them in bankruptcy, and in all different kinds of rental actions, wrongful detainer, tenant holding over, breach of contract, breach of lease actions, and water bills, which are a big deal in Baltimore City. Kay got her undergraduate degree from the University of Maryland, College Park, and her law degree also from the University of Maryland, which is also my alma mater. And she is a board member of the Maryland Consumer Rights Coalition, and former board member. And she currently serves on the diversity committee for the Bar Association of Baltimore City. And so with that, I'm going to take over from here, Kay. Thank you so much. Oh, do you not already have it?
I don't. Thank you everyone for being here after lunch. I hope that you will be able to stay up. We're going to do the best that we can. I don't have any jokes. I don't have any candy. But I have a lot of information that I think will be useful to you. I wanted to first start off where we hope we meet our clients. We don't always meet our clients here, but we hope that we meet our clients. And that's where, when we talk to a tenant, I represent tenants, where we educate them about looking for a property and what they should do before they sign a lease. So one of the things I wanted to do was to mention that you should tell your tenants that they should also interview their landlord. The landlord should not be the only ones to interview them, but they should interview their landlord. And they should check whether or not the property is lead certified, And to assist them in doing that, you can remind them to go to the Maryland Environmental Protection Agency to make sure that the property is lead certified. In addition to that, I practice in Baltimore City, so a lot of the resources that I will be giving you are specifically to Baltimore City. But if you practice in another jurisdiction, you should look into that jurisdiction's information. So the tenant should also make sure that the property is registered as a property that should be rented. So if you go to the Housing Authority of Baltimore City Property Registration Department, the number to call is 410-396-3557. So the tenant can call that number, or you can call that number. I've often called and said, just introduced myself and said, I understand that I have a tenant that is interested in this property. Is this property registered for rental? Because if the property is not registered to be a rental property, then that property should not be, in fact, rented, and it may be actually a hazard to the client. Another thing that you may want to also check is if you Google is my friend, if you Google the Housing Authority violation notices, citations, you can then type in the property address to see if there's any outstanding citations or violations on it, or if the property has the proper permits or any type of violations that may be on the property. That can save your client a lot of headache and a lot of trouble if they can do these types of preliminary research in advance. Maybe they won't pick that property and then have problems later after they've in fact signed for the lease. The client should ask for a copy of the lease. They do not have to sign the lease immediately. They should be allowed to take the lease home, review it, and make sure that they are okay with the terms that are contained in the lease. The client should find out whether they are responsible for what utilities they're responsible for, whether that be water or electricity, because those things are important. Sometimes clients don't know or don't realize what their responsibilities are, but if you can obtain a copy of the lease, go over it with them, that would be helpful to them. They should check the condition of the property. So some of our clients have in the past, or a lot of our clients have in the past, they have to move immediately. So they just find a place, they'll look at the property maybe at night, or they'll look at the property when there's no electricity in the property, and that's never a good idea. So when they go to a house, you should tell them, run the water, flush the toilet, go into every room, go into the basement, see what is going on with the property, and stay there for a while. Maybe 20 minutes or so, walk around, ask questions, go when it's raining, see if the leak, the roof leaks, because this is where they're going to be living, and this is where their family is going to be living. So it's really important that they take the time to properly investigate the property. Moving forward, client has moved into the property, the lease has expired, they're ready to move. You want to advise them to make sure that they clean the property. If in fact they want their security deposit back, they need to clean the property. They need to take a picture of the property, of the entire property before they leave. That includes the walls, that includes the carpet, that includes the oven, that includes the stove, and that doesn't just mean the outside of the oven or the refrigerator. That means inside of it. They need to open it up, and they need to take a picture, because that's going to be their proof as to how they left the property. So if an incident does occur and you have to represent them, you should definitely ask them, do you have any pictures? And hopefully they will have the pictures and they'll be able to give you that information. They should transfer the utilities or turn the utilities off on that property, because oftentimes if they do not contact the utility company, they will continue to be responsible for that utility bill, and they can have problems in the future. You should suggest that they submit a change of address with the United States Postal Service, and if there's any bulk trash, they should schedule bulk trash pickup in advance of their move. So they should not just leave large furnitures or items in the property or on the street, because then the owner may receive a citation and then they will be responsible then for that fine. They should return the keys. If they can return the keys in person, they should do that and get the homeowner or property manager to sign off and give them a copy of that documentation. Often, if our office is involved, I will send the keys to the owner by certified mail return receipt. I will call the owner as well as maybe send them an email and say, listen, I have the keys. You may take possession of your property, but I'm certifying it by certified mail to you. And generally that works out fine. Another thing is, if you're going to be practicing any type of law, you need to know the rules. So it's really important that you familiarize yourself. That's why I brought the annotated code, real property, that you familiarize yourself with the rules. This is a real property, and this is the Maryland rules of the court. So I'm going to have you jot down some really important rules that you need to know. This is not an exhaustive list. But first, Maryland Rule 3-331, which deals with counterclaims. So if you have a client that has a viable counterclaim and you want to file a counterclaim, you have 10 days to file that counterclaim after the filing of the notice of intention to defend. Now, often we get our clients after that time frame has expired. So what you would have to do is file a motion with the court to request that you be able to file a counterclaim, because it's not timely. So the court has to give you permission to then do that. But if you have a compelling story as to why your client did not properly file things timely, let the court know. And generally, we've been successful in doing that. And, you always argue in the interest of justice. It's very important that your client be able to file a counterclaim. Maryland Rule 3-325 allows you to file for a jury trial. You should also see Maryland Rule 3-331F regarding that as well. Maryland Rule 3-711 talks about landlord and tenant law. 3-421 talks about discovery. Now, with small claims actions, and that is with claims that are less than $5,000, you do not have a right to file for discovery. But that doesn't mean you can't get discoverable information. But if you do want to file for interrogatories, that's 3-421. And we'll be talking more about interrogatories later on in the presentation. And 3-5110 is for subpoenas. So remember that although you can't file for discovery, if you have a witness that you want to subpoena to come to court, then subpoena them to come to court so that you can assist in defending the case. The annotated code 8-208 and 8-105 discusses prohibited languages of leases. So I point that out just so that you can get familiarized with it, because every term that might be in a lease may not be a legal term. So in your argument, you can let the court know that, yes, provision A says X, Y, and Z, but that's an illegal provision and it should not be enforceable by the court. So I want to jump to the types of cases that you're going to see dealing with basically damage cases, and that's where the tenant has moved out of the property and now the landlord wants to sue the tenant for unpaid rent, unpaid utilities bills, and allegedly damage to the property. So Amy, if you can help. Yeah. Thank you.
That one's okay.
Okay. So if you look into your packet, this is a complaint that was actually filed against my client. and I redacted the client's information as well as the attorney's information. So there were 2 counts that the landlord alleged. So the first count was breach of contract. So the landlord essentially said that the client entered into a lease agreement, did not fully perform with the lease. Paragraph 9 says the defendant failed to pay the monthly rent for 3 months, and they put the month there. They also was saying that they filed a failure to pay rent action, and a warrant of restitution was filed, and costs were incurred, and this was the late fee. Well, this were the court costs. Then they're saying the tenant left the property in a really bad state, caused all this damage to the property, paragraph 13. Paragraph 14, the plaintiff took several months, to complete repairs to the property because it was so in disrepair. The total amount due, they were requesting. So basically, for this particular case, the landlord was requesting over $15,000. So we saw this. I was like, this is ridiculous. So, well, before I go there, so what I did when I first got the case, I interviewed the client, and my client was on a public subsidy. So my thing was, you can't get any money out of this client. Let me just pick the phone up and let the plaintiff's attorney know that you can't get any money out of this client. Why are you going through this process? Being a reasonable person, I thought that they were going to be like, attorney, thank you so much for the information. Why does my client need to pay all these attorney fees? We'll just go ahead and dismiss this case. Didn't happen. So what the attorney ended up telling me is, this is not about the money. I said, what is it about? Because she had, so now you're telling me you have any money, but this is not about the money. So the attorney says, well, we're trying to get her terminated from her housing choice voucher program. So that's the primary goal, because my client is such a evil person. These are the words that were used. I'm not making this up. So I said, can you say that again? And they did. So that really made me upset. I said, well, thank you so much for your time. Now I know what this is all about. So I said, well, okay, since you're not willing to dismiss the matter, I said, I really don't understand your complaint, because you're saying it took all these months for repairs to be made. You've not attached any invoices. You've not attached any pictures. Help me understand. Maybe we can try to resolve this. Though I know my client has no money, but maybe. So end up getting free discovery, actually. So he sends me over what he says is, this nice Excel sheet and not even any invoices, just an Excel sheet. But it gives me a better picture of why they're suing the client. I said, okay. So client came late, didn't file intention to defend timely, didn't answer interrogatories timely. The district court had then filed for sanctions, and just kind of going downhill. So I said, well, let me try to file my own interrogatories, because this is a large claim. So I did a motion to the court. The court granted it. The attorney was very upset because he didn't want to answer my interrogatories, but he wanted my client to answer his. So we end up filing for interrogatories, which we'll talk about in a second. But what you should do when you first get a client is you need to investigate. You need to really, really interview the client and find out what was going on. Did they return the keys? When did they return the keys? How did they return the keys? How did they leave the property? Who helped them to move out of the property? Was there, family help? Did you have to hire a U-Haul? Did you update your change of address? How did you submit your notice to vacate? Was the landlord on proper notice that you will be leaving? So really, really interview your client. And I research everyone. I research my client. I research the opposing party. So use case search and find out how many lawsuits have they been in the past. And you may find out, about RENESCO actions regarding the case. Google them, see what's on Google, see what's on Facebook if you have Facebook, see what's on LinkedIn. I do asset searches for the opposing parties. Like, I find out if they have money or not. Because if I'm going to file a counterclaim, I want to know I can attach it to something. They have a house, right? So, so really, really do your research to figure out who the players are. If the client has any witnesses that they think, need to testify and come to court, ask them about them and call them if you can. Get date of birth if you can. I use case search too to look up to figure out credibility. So if someone has a list of criminal allegations, they may not be a witness that you may want to call in court. If someone, may not be legally employed, they're employed, but they're not legally employed, they may not be a witness that you want to call for your client. So interview everyone beforehand to make sure that you know the facts of your case and what the other side may or may not say. So the second count to this complaint was unjust enrichment. Now, I didn't pay particular attention to that count because unjust enrichment only comes into place when there is not a contract. So because there was a lease, I felt that count 2 was a frivolous count. So I didn't pay that much attention to it in terms of litigation. So what I then did was I filed interrogatories because I wanted to find out what was really going on with this case. So there's a definition section, and there are standards definitions, but you should always try to also add additional definitions because you don't want the opposing side to say, I don't understand the question, I can't understand the question because I don't know how you're defining a certain term. So we defined complaint, number 11. So the landlord had mentioned several complaints in the pleading, so we defined what we meant by complaint. We defined what we meant by property, and we also defined what we meant by inspection. So because the client was on Section 8, Section 8 does inspections. So when I referred in my questions about what inspections were done to the property, I was talking about what inspections were done with the Housing Authority of Baltimore City, as well as any landlord inspections that may have taken place. So I wanted to make it clear to the attorney what I was asking. So the first question was about, any witnesses that they have, which is standard. The second question was about expert witnesses. Now, I only kept number 2 in because I had space. So in district court, you're only allowed 15 questions. So had I needed to really ask another salient question, I probably would have taken number 2 out because most attorneys or most plaintiffs, they're not going to have an expert witness. So I just threw it in just because I had space to do that. Number 3, basically just asking for documents and asking them to describe how those documents are kept and what the title of the documents are. So I want them to do the work for me. So they have to list the documents and tell me where they're located. Number 4, says, you know, state specifically the basis for your allegation as outlined in paragraph 12. So I used their complaint to actually make my question. You're saying the tenant at the time of possession turned over owed blank and unpaid rent. Didn't tell me the month, didn't tell me the year. So I wanted them to specifically tell me, what are you talking about and how did you arrive at your figure? The same thing for question interrogatory number 5. I referred back to their complaint as outlined in paragraph 15. What damages were done that came up to $5,000? Explain it, you know, explain it to me in detail. Same thing with interrogatory number 6. I referred to paragraph 14 for them to explain. So then interrogatory number 8 says, okay, how did you come up with this large number? You know, attach all supporting documentation, attach all invoices that made you arrive at this number. Interrogatory 9 states with specificity the date the defendant occupied the property. Ironically, not specifically to this question, but they didn't even know when the client left. So you know, interrogatories are really important because they didn't know the date she left. Like, that's interesting. So that's number 11. What repairs were done after the tenant vacated. So with that question, I got a response. I know, you know, repairman X went into the property, but I'm not really sure what he did. So, like, okay. And 14 is if you've issued any subpoenas and received any documentation back from subpoenas, I want to know it too. Because the other side doesn't have to tell you unless you ask. So I went ahead and asked them what they in fact did. So I got some really interesting responses back. So I called back and I said, you know, your responses really don't make any sense. You need to really supplement them. And, you know, by the way, do you want to try to settle this or dismiss it somehow? Because you don't, based on your answer, just reading it objectively, it doesn't appear that you have a really strong case. So you want your client to pay you all this money. You know, I'm free, so I can do this all the time, every day. Like, yeah, they want her to be terminated from the program. Like, okay, got it. So that was that case. It ended up being resolved. The client ended up filing for bankruptcy, and they were very upset. They were like, how dare her? And even when we went to court and we did the notice of bankruptcy, he was like, how can they do this? I said, because that's their legal right. I mean, they got into a whole dissertation with the court about it because they just did not believe that they could legally do this. And I cited the law, and I told them in advance, and they still didn't believe me. But that's okay. I have no hard feelings, even though I was treated very, very poorly. But I'm strong. How do you make that big? Oh, thank you. Right. So counterclaims. So before we get into actual sample of a counterclaim, I wanted to talk about some defenses to some of these cases. So one of the first defense, which Jane mentioned earlier, is this a legal corporation? Like, that is so important. And it can save you a lot of time and energy, because the worst thing that could happen is you actually go through a trial, you file a counterclaim, you have this judgment, but it's not a legal entity. You can't collect. You can't do anything. So you want to also demand strict proof. So that's Maryland Rule 3-308. You want to find out what the client's source of income is, because even if the case is able to go forward, if you're dealing with another attorney that is reasonable, they often will dismiss the case. And I've had several cases where I called the attorney and I said to them, my client gets SSI, my client gets Social Security. Do you really want to go forward with this? Because at the end of the day, you cannot get anything from them. And they were like, well, thank you so much for calling. Can you send me over, some proof? Because I don't need to waste my time. And I faxed them over the documentation, and the case is dismissed. So get that documentation on your initial consultation so that if you do make that phone call, you have the documentation readily available. Another defense that you could raise is constructive eviction. And that is where the house was so inhabitable that really no one should have been living there. So the elements of constructive eviction is series of substantial interference. The tenant was unable to enjoy the property. It resulted in the tenant vacating the property because the property was in such a bad state. So if it's a valid argument, you can add that in your counterclaim.
Can I ask a question? Is that always a warranty of habitability issue, or is it like a subjective? If it's like the conditions for that particular client makes it, and it's constructive eviction, but not necessarily like objectively looking at it would be.
No, it's an objective standard. So if the facts are there, then you weave those facts, into the law. But that's a separate count, because you can have a different count, which we'll talk about a little later, for implied warranty of habitability as well. So these are separate counts that you can, in fact, raise. So I had a case, it was a circuit court case, it wasn't a district court case, where we put in constructive eviction, we put in breach of implied warranty of habitability, we put in breach of contract, we put in breach of covenant, what's it called? Quiet enjoyment? Yeah, covenant of quiet enjoyment. So those were separate counts, and under each separate count, you will pray for your relief, whether it be $2,000, $3,000, whatever the amount is. So if the client left the property without giving the proper notice, but the landlord was on notice that this property was in disrepair, then that's a counterclaim that you can possibly raise. So it's very fact specific. And if the client has called 311 and has inspection reports or have letters that they've sent to the landlord saying, I can't live here, can you come and fix this? The sewage, the roof is leaking, everything, all the facts are horrible, then you can allege it. Another defense you can raise is security deposit. So the security deposit law is 8-203, which is in the real property statute, where the landlord has 45 days to return the security deposit. If the security deposit is not returned within that time frame, then the landlord forfeits their right to withhold the security deposit. And if that then occurs, the tenant can then file for triple damages. Now, if the landlord just says, I'm not returning your security deposit, and does not give an itemized letter and invoices and documentation as to why they're withholding the security deposit, then the tenant has a viable claim and can file then a counterclaim for security deposit. So if those facts are there, then you should in fact file a counterclaim if you can because of that. Now, the landlord can only withhold the security deposit if the damages are beyond normal wear and tear. And again, that's fact specific, and it depends also on the judge that you're before and the evidence that you're presenting. But I've been successful in those cases and received awards for my client, and they got back their security deposit with triple damages, and I was able to actually collect on that debt. So I had an individual landlord, and there was a lot going on in this particular case. It was, she withheld a security deposit unreasonably. During the tenancy, she overcharged the tenant rent when the tenant was on public housing. So, for example, the tenant's rent, approved rent from Section 8 was $300, but the landlord was in fact charging her $500, which is also fraud. So I had a account, and I titled it, overpayment, because I didn't really know like the legal term, but the facts were there, the allegations were there, and the court decided that, number one, it was an overpayment, and number two, they should not have withheld the security deposit, because in the testimony, the landlord alleged that the client took the microwave, and the microwave was the owner's microwave, and that it was conversion. But through testimony, the tenant testified that she brought her own microwave, and when she left, she took her own microwave, and there was nothing in the lease that said that the landlord was allowing her to use her microwave. So the landlord didn't have the proof that she needed. She said the tenant took like the lawnmower or the rake, and the client said, I don't like outside. I don't know anything about keeping the yard clean. I would pay someone to mow the lawn. I didn't take your stuff. And it was just it was a fun case for us, but the landlord was so ridiculous that the court totally believed our client. So it's normal where the landlord can withhold money if it's beyond normal wear and tear. So anytime you turn over a property, the landlord needs to paint. So the landlord should not be charging to paint the unit. The landlord should not be charging to shampoo the carpet. They should take on that cost. That's the cost of them doing business. The landlord should not charge for the ceiling being defective when the roof was leaking. And they do that so many times. And the good thing about some of our clients is because they're on Section 8, they will call Section 8 and a Section 8 inspection would have taken place, or they will call 311 and an inspection would have taken place, and then you can then present that documentation to the court and say, listen, inspector came in, cited the landlord. The tenant was not cited, and this was a month before they moved out. So use your facts, know your facts, investigate to see, what documentation is available. Another defense is breach of implied warranty of habitability. So essentially that means that the property has to be fit for human habitation. And if it's defective and the landlord knows because it's their property, then you can allege that. I'm going to also bring up the public local law of Baltimore City. So it's 9-14-1 deals with implied warranty of fitness for Baltimore City. So you can use that law as well to say that there is a breach of implied warranty of habitability. You can also use it as a defense to breach of covenant of quiet enjoyment. And you can look at Real Property Article 2-115, which says, in a lease, unless the lease provides otherwise, there is an implied covenant by the leaser that the leasee shall quietly enjoy the land. So there is also a calculation that can be done for damages for the implied warranty of habitability. So, and that's in the Public Local Law 9-14-2D. 9-14-2D. So it says that, or what the court will do is, if the property was only worth, let me start it this way. The rent is $800, but the property was only worth $500. So because the kitchen was inoperable, 2 of the bedrooms in a 3-bedroom house was not really functional, they couldn't sleep in there, then the property should have only been rented for $500. So if you do, and they've lived there for a year, so if you do the difference, 300 times 12, then at the end of that count, you can then say, you know, well, we are requesting a refund and a prayer for this amount because they paid this amount of rent, but it really was not worth that amount. A lot of times the landlord will say that there's unpaid rent that's due, and not just because of the terms of the lease, but they're saying that, you know, it took them 6 months to re-rent the property and the tenant did not provide proper notice. So in Baltimore City, the landlord must give a tenant 60-day notice to vacate, and that's under the Public Local Law 9-14. A tenant only has to give 30 days notice to vacate. So you may argue to the court, well, the landlord did know that I was vacating and therefore should not charge these other months where this property was not re-rented because they were unnoticed. Landlords have to mitigate, and they should mitigate their damages, and that's in the Real Property Article 8-207. So if a landlord just says that they're not going to do anything, they're not going to fix anything, they're not going to advertise, and they don't have any proof of advertisement or how frequently they did advertise, then you can raise that in your case. So in your examination of the landlord or the landlord's agent, you can say, isn't it true you didn't advertise this property? You didn't employ a realtor for this property. You just thought that because they left early that you didn't have to do anything and you were just going to sue them. That's not right. So they need to mitigate their damages, and you need to ask those types of questions during cross-examination. One case that I had, well, we'll get to that because it's one of the samples that I have. So let's go to filing a complaint. So you could actually head this counterclaim. It doesn't have to be headed amended complaint, but this essentially was, you know, a counterclaim. So you put in your facts, and then you put your count. So this is how I did the count, and then I put the facts here to support that. So I'm basically saying, you know, there were serious and substantial life and healthy safety conditions in the property. The landlord knew about it. My client suffered damages because of that. Count 2, covenant of quiet enjoyment, put case law, put statutes. Now, this is an old complaint, so what I would suggest, after every count, you actually put your wherefore, okay? So that if one of your counts gets dismissed, you still have the other counts with a dollar amount present. Count 3, this is a security deposit count where it says, you know, the security deposit was unreasonably withheld, we're asking for triple damages. Count 5, breach of contract, rental overpayment. So this is where the client was paying excessive amount of rent when Section 8 only approved a certain amount of rent. Any questions there? All right. Case study. Okay, so I'm really anal, according to my colleagues. So, so I do a lot of charts and to try to stay straight on what's going on, because there's always a lot going on, not just one issue, but it's several issues. So for this particular case, this landlord alleged all of these damages. So that's why these damages are here. Had to change the filter. Carpet, carpet had to be replaced. Had to clean the entire house. Interior door had to be replaced. Had to replace some light bulbs, whether they were in the refrigerator or, in the ceiling. Had to replace mini blinds. Had to paint the entire house. Refrigerator replacement. God knows what happened to the refrigerator. So we still don't know what happened to the refrigerator. Holes in the wall. This one, okay, I'll give you that. I'll give you that one. Smoke detector replacement.
Kate, can you just quickly kind of talk about like what the general standard for holes in the size of what the size of hole in the wall, like what is potentially ordinary wear and tear and what's not?
So if the tenant put up a painting and just use a regular size nail, that's normal wear and tear. If someone punched the wall in because there was a fight in the property, then that's a different story. Now, which could have been the case here, if the landlord did not install the door stopper and the knob punched a hole in the wall, tenant's not responsible for that. You should have had a door stopper. So all of these, allegations were really, really frivolous, and the court realized that. Now, with the carpet, there was a leak in the property, and the majority of the carpet was replaced about a month or so before the tenant moved out. So for them to say I still had to recarpet the whole entire house didn't make sense. And we had the Section 8 inspection reports that said landlord is responsible to replace the carpets because of the leak that occurred in the property. That was the landlord's fault. Cleaning the entire house, this was problematic because the tenant gave proper notice to move out. The tenant was moving the belongings out of the property, and the last day for her to move out of the property, the landlord changed the locks. So she could not do the final cleaning because it was really an illegal lockout. So the fact that came out was she called. She says, I'm at the house. I'm trying to do the final cleanup. The locks have been changed. Landlord didn't return the call, didn't return the text. But now you're saying you had to pay for somebody to clean the house. Interior door, that was just minor scuffing on the door. Light bulbs, that's a business expense. Mini blinds, client testified they never had many blinds. So you just now decided to install the mini blinds and wanted to now charge me. Painting, you need to paint the property. Refrigerator replacement, nothing was wrong with the refrigerator while the client was there. Smoke detector, the client said that she never tampered with the smoke detector. Trash and hauling, that was only because she could not do her final cleanup. Window glass repair and replacement. So landlord, well, let me go to the next.
I have a question.
Sure.
How long is the carpet good in the house? So when is the landlord responsible for replacing carpet in a home? Like if someone's been there for like 15, 20 years, at what point should the landlord replace the carpet?
They definitely need to replace it for 15 years. It's not a hard and fast rule because depending on the tenant, the carpet could be fine. The carpet could just need to be professionally cleaned. Now, if the tenant, dropped cigarette butts or dropped a hot iron on the carpet and damaged the carpet, then that carpet needs to be replaced. But does it have to be all of the carpet, or could it be a section of the carpet? So the landlord has to act reasonable. And that's why it's really important for the tenant to take pictures of how they left the property. Not only how they left the property, but if they can take pictures before they moved into the property, those are really good too. Because I had a client that had pictures, not a lot of pictures, but they had pictures of the condition of the property. So the court was able to see this wasn't even new carpet. And the client testified that, well, I moved in, but you promised me you were going to clean the carpet, or you promised me that you were going to replace the carpet, but you never did. So don't now try to charge me $2,000, $3,000 to replace carpet in this house when the carpet was old.
The other thing that I want to say about carpet is that carpet will frequently have a year rating, a life rating, and so it'll be like a 10-year carpet. And so if the landlord wants to get the landlord can't necessarily get the cost of what the new carpet is, but can get, so if it was a 10-year carpet and the tenant had lived there for 5 years, they could theoretically get 5 years more if the tenant had damaged all of the carpet and all of it had to be replaced, but they shouldn't be able to get the entire cost of replacement because they lived there for 5 of the 10 years that the carpet was good for.
Yeah, so I think, sorry, I'm going to
go ahead.
Over here. But I think what you'll see often in these cases, and I know that I see it pretty often at our clinic in the district court, you'll see something, a line item on the damages listed that says, new carpet or carpet replacement. And they're charging the client for the cost of putting in the new carpet. And that's not the standard that they're supposed to be using to charge for carpet.
And carpet and painting are two of the biggest things that landlords try to get away with charging, and because it's stuff that should be within ordinary wear and tear, they'll try to get it, and they shouldn't be able to get it. And in fact, a landlord that I had at a place that I was renting previously, they tried to say that the sort of walking pattern that had been left in the carpet, like the tread pattern that I had left in this carpet, all of the carpet now needed to be replaced, and they were going to charge me for that. And I said, no, right? No, you're not.
But it is that and painting are probably the most common incorrect charges that you'll see if they're asking for damages.
It's really bad. Yeah, really bad. So in this case, before I get to the window glass repair and replacement, so what I did was a chronology, because when I meet with clients, I usually just let them talk. And then I write notes and figure out what they said in a chronological order and ask them questions later. And then they have to come back in and I have to talk to them again to fill in the gaps. So with this particular client, so she was illegally locked out the house on her last day of moving and cleaning everything up. The property was then left vacant, right? So what happened was, and the dates, I changed the dates and all that kind of stuff, but the locks were changed to state the client had forwarded her address, she had mailed the keys, I certified mail return receipt, but she really didn't need to because they had changed the locks anyway, but she just did, and she owed some money, legitimately owed some back rent money, and she didn't want to lose her Section 8 voucher, so we instructed her, pay the money that is not in dispute. So then the landlord, January 24th of the following year, then writes her a letter saying, we're withholding your security deposit and we're not giving you your money. Then the landlord, being really vindictive, says, well, you know what, I'm going to let Section 8 know that this property was in such bad repair. So Section 8 came in to do a move-out inspection. So then they wrote a violation notice against the tenant, not realizing the tenant hadn't been there since November 27th. So what ended up happening is the place was vandalized. Mm-hmm. And the landlord wanted to get the repairs done on the back of my client. But the court and the judge was terrific and got it, and the client actually prevailed in the case. So this is just an exhibit list, which I generally bring to court with me. So I write down all my exhibits, and then it reminds me, I have to write down what number it was a mark, and then, did it actually get introduced? Because I don't want at the end of my case that a document that I want to introduce didn't get introduced, because that could be, detrimental. So that's just a log that I have for cases. I wanted to give you all some resources to resolving disputes. So and this is Google again, the Maryland Association of Realtors actually has a security deposit calculator where you can put in the date the deposit was received, when the tenancy ended, the amount of deposit, and it will spew out what the interest is. The Attorney General's Office, under the Consumer Protection Division of the Maryland Office of the Attorney General, has educational materials on landlord-tenant. So it's about a 30-page booklet that you can download online. Community Mediation Center is also a free service that you may be able to take advantage of for your client, where if the landlord and the tenant are willing and able to, they can sit down and try to resolve the dispute, before court. Now, there is day of court mediators on certain days, but if you want to be proactive and you think it may be a matter that can be resolved, then you can try to refer the clients there, or you, of course, as attorneys, you can try to negotiate a settlement on their behalf. If you're dealing with public housing tenants, you need to get familiarized with the federal law. So generally that's in 24 CFR, I think it's 9-82 perhaps, but that will give you what the federal law is for, subsidized housing. Are there any questions? Sorry, go ahead.
I have a question about the 914-2B calculation, where you were talking about if the rent is higher than the property value.
The public local law.
Yes. Is that, so the way that's calculated is the property value, I guess it's the monthly rent compared to what the year's worth of rent would be?
Well, let me just read it to you. Okay. That might help. So it says,
so is that an affirmative defense, or is that a separate claim that you can, I guess, bring if you?
I would do it affirmatively. Okay. I would do it in my counterclaim.
Okay. Okay. All right.
You can definitely raise it, but if you don't have a counterclaim in place, the court can't really do anything. They can get the information and they can say that there was a breach, but they can't award any money if there's no counterclaim on the record. So it says damages shall be computed retroactively to the date of the landlord's actual knowledge of the breach of warranty, and shall be the amount of rent paid or owed by the tenant during the time period less the reasonable rental value of the dwelling in its deteriorated condition. So that's where the example was. The rent was $800, but it really should have been $500 because of the deteriorating condition. So we're asking the court to give back the difference.
Okay.
Or abate whatever rent may be owed.
Okay.
The landlord.
How do you come up with the $500 figure?
It's just a reasonable figure. I mean, it just depends on the size of the house. You could even do percentages if you want to. You could say, well, the client was only able to use
a certain portion.
60% of the house, and then do 60% of 800 equals whatever. You just have to explain to the court how you came up with the figure, because it'll just help them. Because there's no hard ass rule, but just to help them along the line, like, Your Honor, this is how I came up with my number, and that's what I want you to grant me. That's all. Yes.
If the property is not lead certified and the property owner did not tell the tenant before they moved in that there was lead in the premises, and it's not registered as a rental when it's supposed to be, would you argue that would be a complete defense to, a breach of contract case trying to seek unpaid rent?
Yes. So there actually is a case that speaks specifically about the property not being registered.
Right.
And I do not remember the name of McDonald.
Oh.
It's Nick something. But that was a case that came out probably 5 or so years ago. But it speaks specifically to that, and I think it was a retaliatory eviction case. It was either a retaliatory eviction case or rent escrow case, but the Court of, I think it was the Court of Appeals, it's a Court of Appeals case. The Court of Appeals said, we are not going to allow a plaintiff to file a lawsuit and try to obtain damages when they did not, in fact, follow the law. Similar with the debt buyer cases. If you are not registered or licensed, your business is not licensed, we're not going to allow you to come into the jurisdiction and take the advantage of our laws when you did not follow the law.
Yeah. As far as wear and tear, I mean, I had this actually, it was a case yesterday, Montgomery County. The landlord repainted the place, and he tried to charge my client for it. But my client had painted some of the rooms, like I think his daughter's room with, the walls, and so it wasn't, we couldn't claim, okay, well, it was normal wear and tear, whatever, on the paint. But so did the landlord have a legitimate right to?
Yes.
And could charge?
If the lease said that the tenant cannot alter the property without, usually it says written permission, and they changed the color of the painting, then the landlord could, in fact,
charge for the whole, repainting the entire, or just those parts of the rooms, the particular of the rooms that was.
I mean, you could argue just the particular rooms, if the other were intact.
And that goes to the other stuff. Essentially, who has the burden of proof of showing that everything was in normal or acceptable condition when it was turned over to the landlord? Is it the landlord?
Well, the plaintiff. The plaintiff has the burden. So the burden is on the plaintiff by the preponderance of the evidence to show whatever their allegations are. Okay. Now, the defendant can rebut that. So if the defendant has pictures, if the defendant has email correspondences, then the court will take that into account. Now, if the plaintiff does not make their case, then you need to do, a motion at the end of the plaintiff's case in chief so that matter can be dismissed, essentially, or judgment in favor of your client. Because why put on your case if you don't have to put on your case? So you should always do a motion after the plaintiff's case in chief if you believe the plaintiff did not make their case.
In many jurisdictions, if the amount of paint, if it's only one coat of paint required, paint, the room, say it was a very pale pink that the daughter's room was painted or something like that, that frequently will be considered still ordinary wear and tear. But if it requires a second coat of paint, that's usually going to be a situation where a paint charge can be charged. But saying like there were handprints on the walls or
Right.
And my client actually painted over, but landlord was saying that, okay, like you could still see the the stuff through whatever he painted, which I would think he would have the burden proof of showing, or would my client have the burden of proof of showing that no, you couldn't see it? You know what I'm saying? Like that would.
that sounds like you need pictures to be able to.
Yeah, exactly.
And it was still alteration and breach of the lease.
Yeah.
So the court may be like, you shouldn't have did it, period.
Yeah, absolutely.
Now, do you think changing the locks is something that can be legitimately charged? I mean, as a matter of course, are landlords changing the locks anyway when tenants leave before new tenants come, or do you think that they can legitimately charge that against like a security deposit?
It depends. Like some apartment complexes have or condominiums have special keys, and those keys are really expensive. So if they didn't return the special key, not just a regular knob, but just a special key, then they could change that. And some leases will actually say it. If you don't return the main building key, that is going to be a cost of $50. So they already outlined that in the lease. But if it's just a regular changing of the locks, I think that's unreasonable, and that's what I would argue.
Can you talk a little bit about rent escrow and the process for that if the client is currently being, so this would be in a situation where the client is being sued for non-payment. So before we get to this action, because this is something, so if the client is being sued for non-payment of rent or for damages, that's what we're talking about. Can you talk about rent escrow because you were talking about that a little bit before?
Sure. So if the client is being sued for rent and there are conditions that exist in the property, the client can raise as a defense rent escrow. And rent escrow was when they're basically saying there's conditions in the property that make my house not safe, and I want to raise those conditions. So in the district court for Baltimore City, the judge at the rent court level can ask some preliminary questions and determine whether or not to have the case consolidated to a rent escrow case. Then a housing inspector will then come to the property, inspect the property. The case will be reset on the rent escrow docket, and then there will be a hearing regarding whether those conditions exist and are those conditions a threat to life, health, and safety. So the tenant does not have to pay a filing fee when they raise it defensively. They can also raise it affirmatively. So a client, without being sued for failure to pay rent case, can just file a complaint in district court saying that they're having conditions in the property and they want to essentially pay their money into the court and not give the landlord any money until repairs are made. Our clients, through the Legal Aid Bureau, are eligible generally for a fee waiver, so they wouldn't have to pay the filing fee. But that is a way that if someone is living in a bad housing situation, they don't have to pay their money to the landlord. They can pay their money to the court, and if it's really bad, the court can actually terminate the lease so that they can go and live somewhere safer.
And certainly, if this is a client that you're representing through MBLS, the client is also entitled to a fee waiver. The other questions I had. Here.
I have a question about rent. Sorry.
Yeah.
Do you find I find a distinction between, I don't know if there's a rule, but between certain judges that if the person is there, they filed a rent escrow, and they have the money at the first hearing, to pay for the months that they should have paid into the escrow. Some judges don't allow them to pay that day, and then other times the clerk, when they actually file it, they'll accept the money. So I don't know if there's actually is a like rule or discrepancy about when you're supposed to pay into the escrow. So I just don't know if you've seen that before, where sometimes
I haven't, because the clerks can't take money regarding the run escrow until they're not supposed to, I should say, until there's actually an order from the court as to what the amount that they're supposed to pay in to the court. Now, some judges will, if it's the first day or the first time in, some judges won't initially take the rent that the client may have, because it might be a life, health, and safety issue, but it might be a life, health, and safety issue that can quickly be repaired. So to take the money, get it deposited in Annapolis, to then next month have to then dismiss the escrow, issue the check, which can take 4 to 6 weeks. It holds the money up so much that the court likes to see at least how the case is progressing, because then they may just order the tenant to pay over the money. They may just abate a certain amount of the money. So it really just depends on the violation and the timing of everything.
If you have a tenant who has a serious issue where perhaps the water has been shut off or something like that, so there's a law that is specific to Baltimore City that this can be in fact a crime that the landlord has committed if they've shut the water off. So do you have a sense of like when you would encourage a client to potentially do that, or would you always potentially encourage a client to file charges against their landlord for charge of eviction?
Why is the water off? Is the water off because the landlord instructed DPW to turn the water off, or is the water off because the tenant did not pay the water bill in which they are responsible for? So that would determine how I would advise them. What we've also seen is, say the BG&E is cut off, and it is in fact the landlord's responsibility to pay for the BG&E. So then I would advise the client to file a complaint for denial of essential services. And they can do that on Calvert Street with the court commissioner. So it just depends. It just depends who's the responsible party for the water. So I would try to investigate that a little bit more before having someone possibly be incarcerated first.
Have you ever used the statute about where a tenant can get out of paying rent if they have like a medical emergency, where if they're going to be not able to live in the property any longer? I had a landlord attorney actually bring it to my attention a few weeks ago and hadn't realized it. And just
we've used it before.
And you've been successful. And
we have. I mean, it's for limited circumstances. It stays the eviction, if granted by the court, I believe only for 15 days, but the tenant has to obtain medical verification. So usually eviction prevention, which is on the second floor in Baltimore City, they can walk the client through that process and give them the proper forms to fill out. But we have, on occasion, helped the client to do it, but they have to get medical verification, and the court will grant it if they find that it's legitimate. Any other questions?
I think the one other thing that I want to say about all of this is just that I think these cases, more than the other cases that we talked about today, can be really difficult because they are very fact dependent, and it's a bit more complicated than some of the other areas of law, just because the client can potentially be entering the court system in a variety of different ways. You're talking before about in a perfect world, you would encounter the client before they were moving in, and you could have them do a proper inspection and all that. And the real problem is that many of the people that we, because of both a lack of affordable housing and a bunch of other issues, we wind up almost never encountering, at least I wind up almost never encountering clients that are in that posture. And the other thing is that the reason that these cases are so important is that, obviously we're talking about the right to housing, the right to safe and habitable housing, and this really is a human rights issue. And raising, and there are certain instances in which raising a human rights argument is useful and helpful in cases that you might potentially pursue. And if you want some resources on that, I think Kay actually has some resources about inserting human rights arguments. No? Am I making this up? Then there is another attorney at the Legal Aid Bureau who has some resources about inserting human rights arguments into some of the cases that you file. But the thing is that landlords are frequently not accustomed to having people fight them on these. They are accustomed to going into rent court and just evictions for everybody across the board, no problem. And then there are the collection attorneys that they potentially use, who in some cases in Maryland are essentially the same. It's all the same heading. It's just a different entity that is suing on behalf, because you can get attorney's fees as long as they're not in-house attorneys. So that's why they kind of segregate them. They're also not accustomed to ever seeing anybody fight these kinds of cases. And so, although you may come out of this training session feeling a little bit like, not sure I could take a landlord-tenant case on, I would encourage you that you could, you absolutely could, and that also that it's needed.
It is. It really is. And I will say that on there's certain plaintiffs that generally have their cases set on the affidavit judgment docket on Tuesdays, and some that generally have it set on Wednesdays, because that docket was actually consolidated to those 2 days. A few years ago, prior to that, affidavits were kind of all over in whatever courtroom on whatever day. So the court actually consolidated them to specific courtrooms on specific days. And the plaintiffs, it was really kind of something for the convenience of the plaintiffs, because they were filing, hundreds or thousands of these cases, and so having to come in and have one case in the morning and then a couple in the afternoon every day of the week, okay, yes, it's just very inconvenient to potentially have to sit in the courtroom all day for 2 cases. So they consolidated it, and so the plaintiffs, so generally you're going to have like I see the same plaintiffs' attorneys on the cases on Tuesdays every week. And so the one advantage to that is that, if you come to the clinic weekly, you'll see, and if you start taking these cases, you'll see the same collections attorneys over and over again. There are certain collection attorneys that only do landlord-tenant stuff. That's the only type of collections they do. There are, the debt buyer attorneys, they don't really do any other type of case. They only do debt buyer cases. So as you start taking these cases, you're going to get to know the attorneys on the other side, and you'll kind of know how they operate. And I've seen attorneys change the way that they file their cases because we started challenging things. Because there's one plaintiff in particular who would almost every case I saw where they were alleging damages, they were charging the client for all the new carpet that they had put in. So I started taking all of those cases when I would see them come up on the docket, and I kept seeing that issue. So we kept filing NOIDs and getting people representation, and they're not doing that anymore. So, that's one plaintiff of many, but don't underestimate the impact that you can have, because you know, that's a small change that can mean a lot for a lot of people.
And it makes a difference because, you know, even when you first start, you know, they're going to say, oh, they're green, they don't know anything. But as you keep fighting them, when they see me now, they're like, what do you want? Because they know, like, it's not worth it, you know, and they know that their client is wrong. So just tell me what you want. So I want you to dismiss the case. Okay, done. So because they know. So, you know, once you start to build your reputation and really fight for the clients, they'll settle. They'll settle.
All right. I'm going to double check here. I don't have anybody else that has questions. And
so while Amy's kind of wrapping up the webinar, I'm just going to do a plug for a couple of things. One is the clinic that you've heard me talking so much about. If you're interested in coming, I'm there every single Tuesday in the district court. Just shoot me an email, call me, just let me know when you want to come. And like I said, you know, the clinic also runs on Wednesdays, so if Tuesdays are a bad day for you, I can get you in touch with the person at PBRC who runs the clinic and go on those days. So both days are great, and it's a really great way to kind of get your feet wet in these cases. The second plug I want to give is for more webinars. So MVLS just started doing a third Thursday webinar series. It's the third Thursday of every month, and they're just short 45-minute to 1-hour webinars on subjects that aren't, you know, they're not necessarily substantive like this. It could be a procedural thing. It could be, they're generally topics where it's a whole day training like this isn't really warranted, but it's something that would be of interest to our volunteer attorneys. So, for example, the first one that we did in July this month was on the Fair Credit Reporting Act and looking for affirmative claims. There's the one in August is going to be on the trust fund recovery penalty. It's a tax one. And then, you know, we're going to have an expungement one. We're going to have one, there's one on avoiding pro bono burnout, so things like that. And so it's every third Thursday of the month. You can sign up on our website. Please do so. They're really great, and it's a good way to kind of stay engaged.
Great. Well, it doesn't look like we have any questions from anybody on the phone. And if there are no more questions from the room, I guess we're going to wrap up early. I want to thank Kay very much for presenting, and also everybody else who presented earlier today, including Chelsea, who's still in the room. And I want to thank you all for coming, and I want to thank everybody on the phone for joining in. We really enjoy doing stuff like this. If there are topics that you would like to see, please shoot me an email and let me know. I'm happy to. It's something we can either do for one of our third Thursday webinars if it's a short topic, or if you want to see a couple-hour training or another all-day training on a particular topic, you can let me know, and I can potentially work on that. But with that, I'll wrap things up and say thank you all so much.
Thank you.